Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hi. Welcome. Thanks so much for coming to spend part of your day with me today. It is Friday, February 20th, 2026. And it's a lot. This week has been a lot. Has it been a lot for you too? Some of the saddest news that I've heard, today, let's say some of the saddest news that I've heard today, or actually yesterday, is that Eric Dane has passed. He lost his battle with ALS and he passed at 53 years old. I want to tell you that all of my kids have watched Grey's Anatomy in its entirety. All however many seasons there are, at least 5 times. Huge Grey's Anatomy fans in this house. 53 years old, Dr. McSteamy, Dr. Mark Sloan, has passed at age 53. He passed yesterday following a courageous battle with ALS. He spent his final days surrounded by dear friends, his devoted wife, and his 2 beautiful daughters, Billy and Georgia, who were the center of his world. ALS is brutal. It robs you of everything. Ask me how I know, or don't ask me how I know, but it has touched my family personally, and I will say that ALS is one of the worst, most brutal diseases that anyone can have because it takes everything away from you. First your arms, then your legs, then you're in a wheelchair, then you can't move anything below the neck, and then once you lose your voice, at least that's how it was for my personal experience, once that person lost their voice, it was the end. And so sad. He passed within a year of his diagnosis. It is horrific. And I'm so sad about it. He's married to Rebecca Gayhart, who is also an actress. And it's devastating. I know it's horrible. It's one of the worst things that anyone can ever get. Today we are going to go to Plymouth Superior for the 2:00 Lindsay Clancy hearing. It's a motions hearing. Lindsay Clancy will be there in person. And so, prayers to everyone in the chat who's lost a friend due to ALS. It's horrific. Right. And your mind is still there, right? Your mind is still there. Your body is what leaves you. And it's tragic. Yeah. Rebecca Gayheart. I don't. Was she the Noxema girl? She was also in a TV show. I just can't remember what it is right now. I've been working on so many things this morning that my ADHD, adult onset, self-diagnosed, has been just all over the place. Trying to figure out what to talk about, what we're going to do. Well, first thing we're going to do is watch the Lindsay Clancy hearing live. There are a couple of motions that were filed yesterday by her attorney, Kevin Reddington. If you're not familiar with Lindsay Clancy's case, there are extensive show notes below this video to catch you up. And we learned a lot more about Lindsay Clancy's case and the postpartum psychosis that she suffered from prior to taking the lives of her 3 beautiful children and then jumping out of a second floor window, trying to take her own life. But she did not succeed, I guess. And now she is a paraplegic. And so there's issues with the logistics of even getting her to court. 3 motions were filed yesterday by Kevin Reddington. One is a motion for a bifurcated trial. And that is Reddington is asking the court to separate Lindsay Clancy's trial into 2 phases. In the first phase, the first trial, they would determine guilt, whether or not she in fact did take the lives of her 3 children. And then he's asking for a separate trial to determine whether or not the government is able to prove beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect to the extent that as a result of such disease or defect, she was unable to appreciate the criminality of her conduct or conform her conduct to the requirements of the law. We recently learned a lot more about Lindsay Clancy's case when she filed a medical malpractice suit against her doctors and some other practitioners that had loaded her up with all kinds of meds with black box warnings and failure to treat her properly and things such as like that. It is in the playlist. I think I've already linked it below this video, but it is entitled something like Lindsay Clancy's medical malpractice case. And I remember doing that case when I was in Mexico with you, or going over that lawsuit that she filed. And many of you who are in medicine were horrified by the drugs that she was put on. And Lindsay Clancy was a nurse herself. It's devastating. The second motion is the defendant wants to videotape the state's Commonwealth's expert psychiatric exam of Lindsay Clancy. Their argument is that they have a right to be there in person. They don't want things getting mixed up. And what Lindsay Clancy tells the defendant, the Commonwealth's expert psychiatrist, and so they want to have that videotaped. It's something that's commonly done here in New York. I don't know if they do that in Massachusetts typically, and so I can't opine for you whether or not that will be granted. The third thing they're asking for is that the jury panel names and identities be released to them prior to jury selection. The way it's usually done is that the lawyers come into court, they're handed a stack of jury questionnaires and they have to go through them on the fly. Kevin Reddington wants them in advance confidentially so that he's able to do his due diligence into the jurors. And so that's what he's asking for. Whether or not that'll be granted, I'm going to jump on the Zoom, and what I'm asking you to do, please, if you for some reason happen to be in the Zoom, please, for the love of the traveling Mary, please make sure that you are muted so that nobody can hear me talking. Otherwise, what I have to do is mute myself and not speak while the Zoom is on, because I don't want my voice coming through, coming through the speakers, because that happens sometimes. As I told you the other day, I have been speaking to Ahmad Cruz about coming on the show. We had been talking about him coming on tomorrow, which is Saturday, and I'm waiting to hear back on scheduling, but a lot of things have popped up on the Edric Faust case. And one of you sent me a video from a guy on Facebook who's been following this Edric Faust debacle. And he claims that many jurors have reached out to him and have told him that they were intimidated by the fact that is he a senator? Houston Gaines was in the courtroom, and they felt like if they didn't find him guilty, that people were going to come for them. So there's a lot of things happening, going on right now. And so we may not be able to get it set up for tomorrow, but rest assured, he has told me that he can't wait to come on and talk to you guys. And so we got that. Yes. Yes. Among other things, like one of the jurors was just like, I just wanted to go home. I was tired of fighting. So I just went guilty. Houston Gaines. And there was a guy, I think, who was a suspect, whose name was also Gaines, who may have been related. There's a lot. Oh, Tiny Jesus is here. Don't worry. Tiny Jesus is right here for us. I mean, I guess nothing would surprise me at this point because we've seen so much shenanigans, tomfoolery, and ballyhoo in just about every case that we have covered. And just one of the avenues to an appeal and or a new jury. It has also been reported that the defense team with their give, send, go money is trying to convince Brian Steele to come onto the appellate team. It has not been confirmed officially. However, they are working on it. And so that is another excellent, something that's hopeful anyway, for Edric Faust. And so if you can spare any dollars, please think about contributing to the defense fund for Edric Faust, because I'm just beside myself. It's really affected me in a way that I just didn't know it could. It's crazy. And why do they have me in civil D instead of criminal 4? I don't know, but this is what they gave me. Resume login. I'm not going to I'm not going to say where it is or anything. There's crazy people out there who are trying to contact the jurors and everything else. So you're in civil D too? All right. Thanks, Mass Dad. That's the info that they gave me, but the calendar says it's in criminal 4, which is what I asked them for, but this is what they gave me when I called. It's supposed to be Judge Sullivan, according to today's docket. Another wild thing that I found out about, because after this, we're going to watch the super secret hearing that happened yesterday on Karen Reed's cell phones. And I told you this yesterday. That hearing did not appear on the court docket. I even saved it. I have the court docket from yesterday, the entire calendar from Norfolk Superior. That Karen Reed hearing was nowhere on that docket. So I don't know how they found out about it. I don't know how Kate Peter knew about it and showed up and apparently accosted Karen Reed in the hallway, screaming nasty things about her. It was kept secret. And yet some people were there, like GrantSmithEllis was there, and he got some video of people outside the courthouse afterwards. So we're going to look at that. Karen's attorney, Benjamin Urbelis, came in to talk about why the phones should be given back to Karen. Judge Doolin heard it. And then Mark Diller, the O'Keefe civil attorney, called in to make an argument, even though he's not involved in that case, didn't put any papers in. And Cosgrove got up and argued why they should still be able to hang on to the phones, despite the fact that Doolin said they can't search the phones. The court officers didn't even know, huh? No, Tiff, you did email me, and that's how I knew about it. But when I pulled up the court calendar yesterday, it's not on there. And there's no docket number for this case. It was filed under a random search warrant number. You can't find the court file. It's being kept hidden. It's being kept hidden and secret. No one has the papers. Judge Krupp's order saying they can't search the phones is impounded. Yesterday's hearing was kept secret. And it's wild. Why? What are they trying to hide from you and me and everyone? I think that's a rhetorical question, as you know, but I'm going to ask it anyway. Aiden said Cosgrove is using his case number, but I looked in his case number and the papers aren't in there either. They filed it under a search warrant number initially. And then all of a sudden, Cosgrove has self-appointed himself to keep fighting. But we're going to watch that after this. This is what we're going to watch first. Yeah, how did Grant and Kate Peter know about it? They're hiding everything. They're hiding everything. I also have for you today some other interesting information, including the original witness statement, if you want to call it that, of John O'Keefe's niece, Kayley, taken by DiCicco. And she said a lot different things on the stand than she did when she gave her statement to DiCicco. So we're going to take a look at that as well. Hold, please. That's right, Lauren. Last time they did that, Hank was hiding the hearing from Karen and her team. Yeah, there's shenanigans, tomfoolery, and ballyhoo going on there. And it's wild. And the world is watching. Thinks we are the lucky ones who are becoming a member. Bethany says, I believe he is in Mind of a Murderer. He plays McDreamy's brother, I think. I think it's beautiful. They did another show together. He'll be missed. I know. So sad, Eric Dane. Thanks, Bethany, for your 5. Music to My Soul says, yes, this week has been a lot. I took Foss' conviction really hard. I can't imagine how he must feel. Thanks so much for helping us process it. It's unexplainable. It's unexplainable to me. So much reasonable doubt. Shenanigans with the DNA. And, there's a lot of stuff that Ahmad Cruz wants to talk about now that the case is over. All the things that were not allowed into the trial. He tried to fight the DNA. The judge wouldn't allow it. He tried to argue consent. The judge wouldn't allow it. I mean, was the fix in from the beginning on that case? There's a lot that we don't know. Thank you, Sassy Ducks Diaries, for your 5. And she says that 4-person's voice was shaking so bad they all sounded like they were sad. Sylvia was in the courtroom and she came on the show and she said it didn't seem that way in person at all. I know it sounded like that to us because we couldn't see her. But Sylvia said she didn't seem upset or shaking, or it was just the way we heard it on the audio. But thank you for pointing that out. Thank you for your 5. Cruz said, who's protecting Chris? Yeah, I mean, the fact that now some jurors are allegedly saying that they were intimidated by Houston Gaines being in the courtroom, hugging the family, says a lot, doesn't it? Because he's the one who promoted that bill, the Coleman Baker Act. He's the one. And we looked at his tweets the other day, or whatever they were, his Facebook page, I think. Thanks, Charlie. But listen, it may not have been Chris. There were 2 other male white suspects who were considered suspects from the very beginning of that case. And there was never a black suspect. And so sus, right? So much sus. And we wait. It is 2:04. I think there's another case also on the calendar at 2:00. So well, there's 2 other cases, so maybe they won't start the Zoom until it's Lindsay's turn, Lindsay Clancy's turn. I mean, we could be in the right place, Mastad, because I think Judge Sullivan, isn't he also a civil judge? He may just be sitting in this courtroom, is what I'm thinking. Laura says the intimidation makes more sense than the verdict. Yeah. Oh, I heard it too. And that she sounded nervous and sad. I heard it too. It was a black woman, the only black woman on the jury who was the 4 woman. And I heard it too. It's just that we heard from Sylvia, who was actually there and had a good sight line of her. I'm not saying that any of this is true. I'm just saying that this is what I heard someone say, that many of the jurors contacted him His name's Charles Hardy. You can find him on Facebook. Oh yes, we'll do the affirmation while we're reading, Mitchell. Thank you for reminding me. We have affirmations for a badass, and we pull one every single day until the deck is done. And there's only, this is the last card. All right. I have another deck after this, so we're good. All right. You ready for today's badass affirmation, my friends? It is, you are magic. Own that shit. You are magic. Own that shit. You're all magical. All of you. Every single one of you. And I love you with all of my heart. Diane says, I could not watch the Foss trial. It was upsetting me too deeply. I'm in week 3 of radiation chemo treatment, and the sadness I felt for him was overwhelming. Thank you for exposing the ugliness. Well, healing vibes, all the healing vibes to you, Diane. You got this. I hope you're feeling okay. That's terrible. I'm sorry to hear that. Hi, Scott McGinnis. Did you go to court yesterday? Scott says, yesterday, Karen Reed's hearing was outrageous corruption in your face. Cosgrove is DA Meatball Marcy's hired gun using the red tape of the law in the most convoluted and disingenuous ways. It makes no sense. It makes no sense unless they really, 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 really are trying to get Karen Reed on something, or unless they've already tampered with her phones, and to give them back would just be if her, let's just say, maybe if they did tamper with her phones or search her phones or do something to her phones and they were to give them back, and then Karen had her experts examine the phones, it would be known. It would be known. Do you think that could be it? Because they've had these phones for over 2 years. They've had them since January of 2024. They've never searched them, allegedly. And they've said in open court that they haven't searched them. They never sought a warrant to search them. But it seemed like Judge Doolin was it seemed like Judge Krupp was going to decide that, well, the warrant that they got initially is enough, but he didn't. He said, no, you can't search them, send them back. But we can't see the order because it's impounded for whatever reason. Next thing, they will come up missing. Oh, yes, Elaine. Well done. Well done to you. Proctor lost his phone. Proctor lost his phone. Put some software on it. Could also be done. Thanks, Angelique. Yeah, maybe they're in the same condition as the Lexus, right? After the Commonwealth got done with that Lexus, what was the condition of that Lexus? Well done. Good citizen. Good citizen says, love the way we are thinking. I mean, how else are we supposed to think? We still don't know why Sergeant Good has been suspended. We still don't know. I guess it's anybody's guess, right? WCVB. Is it WCVB on their website or on their, hold on, or on their YouTube? Except there's a commercial.
Of the Commonwealth's evaluation position. My understanding was that there was no objection to the.
I can't boost it, you guys.
With the only proviso on that dealing with some of the actual testing. So I don't know where we stand on that.
Yeah, Sean, I did just receive.
I apologize, but this is as loud as it will go.
These motions position was that we had no objection to the recording of the examination of the defendant. We would only object to recording of the testing process because of proprietary rights for the standardized testing.
Mr. Reddington?
I don't know the impact of videotaping the proprietary rights for standardized testing. First of all, I would suggest that like come under W for who cares. We're not here to protect proprietary rights of private businesses and enterprises, number one. Number two, personally, I don't really care about the proprietary rights. My concern is what the actual tests are going to be, how they're going to be implemented, how they're going to be administered. And I can speak to certainly Untitled Chapter.
Okay, hang tight. I found it. We can rewind it. We're going to start from the beginning. And I was able to boost it, so we're going to be better. We're rewinding to the beginning, and here we go. Lindsay is in court.
Number 2 on our list.
Thank you to WCVB for doing the Lord's work and putting it on YouTube so that I can actually boost it. Okay, here we go. Back to the beginning. This is Judge Sullivan, I believe, and Lindsay. It looks like Lindsay's sitting at defense table, which is to the right. Oddly enough, the defense table and the Commonwealth table are side by side, unlike most of the courtrooms we've seen in the Commonwealth of Massachusetts. Here we go.
New York, good afternoon, all. This is called the criminal court list for Plymouth County at Plymouth on 2/20/2026. First case is going to call is number 2 on our list, 2383 CR 198, the case of Commonwealth versus Lindsay Clancy. This case is called for motions for the record of the defendant as president before the bar. Counsel for the record, begin with the Commonwealth.
Good afternoon, Your Honor. I'm Duxbury with Commonwealth.
Great, good afternoon.
And Shannon Buckingham also for the Commonwealth.
Buckingham, good afternoon.
Good afternoon, Judge Kevin Reddington on behalf of Lindsay Clancy.
Mr. Reddington, good afternoon. Ms. Clancy, good afternoon. All right, so this is a matter gone for a number of reasons here today, I think. But first, I just kind of want to know, we've talked about the evaluation. And I know there was a motion that was just recently filed. And by recently, I mean just the last day or so. So I'm not sure we're gonna address those motions that were filed. We do gate on those, but one of them that was filed that I think didn't know if we could take up a little bit, and that's one regarding the taping of the Commonwealth's evaluation. Now, I know we've talked about this for a number of times, so I didn't know if we can address that of the Commonwealth's position. My understanding was that there was no objection to the taping of the evaluation, with the only proviso on that dealing with some of the actual testing. So I don't know where we stand on that. Commonwealth?
Yes, Your Honor. I did just receive these motions yesterday, so I don't have any case law to argue or anything like that. But our position was that we had no objection to the recording of the examination of the defendant. We would only object to recording of the testing process because of proprietary rights for the standardized testing.
Mr. Reddington?
I don't know the impact of videotaping the proprietary rights for standardized testing. First of all, I would suggest that like come under W for who cares. We're not here to protect proprietary rights of private businesses and enterprises, number one. Number two, personally, I don't really care about the proprietary rights. My concern is what the actual tests are going to be, how they're going to be implemented, how they're going to be administered. And I can speak to certainly Nigel, my consultant who's here today. I can speak with him regarding that. I know as far as the testing is concerned, usually it's the usual judges. You're well familiar. Minnesota multi-phasic personality, Beck inventory, all of those tests. So I don't really have a problem with them not videotaping the actual filling out of the squares and the actual tests. So I think we can agree that it would be the interplay between the government's doctors and Lindsay, as far as them asking her questions and her related statements, that would be videotaped.
Well, I don't know if the parties can come to a stipulation. If we can't, my suggestion is to pick a date to argue this motion
Okay.
prior to, if I remember, sometime early April, the dates that have been set. And that would allow all parties to kind of get meaty information as to the need for not taping the testing or the no need for it. So then I can fashion a decision. But I want to make sure that it doesn't slow down or interfere with the actual testing.
Your Honor, we have the testing scheduled for April 10th.
Right.
I may have misheard, but I thought defense counsel just said that he had no objection to not recording the testing. So if that's the case, then I think we could come to an agreement.
Mr. Rankin?
Again, I just would like to consult with my own experts regarding that, but I feel myself that I don't really have an issue with not recording and filling out little swears and that type of thing. I have no problem.
All right, so what do we do? I'm going to allow the videotaping of that. That will include the testing as well.
Good.
If either party wants to strike that or impound that part of it, I think we can do that. Call.
Could we do the reverse and just order the testing of the interviewing? And if there is some reason that that's
No, I'm saying, there's no question about, it doesn't sound like either side is objecting to the evaluation itself being videotaped. The only issue, it seems to be, is whether or not.
Yes, if you want to come to your screen, that is Lindsay in court. Lindsay Clancy was transported from Tewksbury State Hospital, where she has been confined since her arrest, and she was brought to court today. Interesting to me that the court is as crowded as it is today. She's the one who's paralyzed. There are extensive show notes underneath the video, if you're not familiar with the case.
The testing itself is videotaped. And now I'm hearing it probably isn't much of an objection. So what I'm going to, my suggestion was to allow the taping of the evaluation and testing. And if somebody wants to, for me to reconsider it and come forward with any additional evidence as to why the testing itself shouldn't be.
Well, I think that, it puts the Commonwealth in a position where we received this motion yesterday. I haven't had a chance to research it or respond, and yet there will already be a decision allowing that taping.
But you
that
want to tape it.
We're objecting to the
Everyone
taping
wants
of this.
Everyone wants to tape, you want.
I don't want to take the testing portion.
All right, okay. All right, so why don't we'll, what I don't want to do is I don't want to delay the testing.
Right.
So, how much time would you need to prepare for this motion?
As you well knows, I'm on trial now in Dedham Superior. I'll have a jury out probably Monday or Tuesday. I would say a lot of the courts are putting that stuff at 2 o'clock in the afternoon now, so it's a little difficult. How about the 2nd of March? Would that work? It's Monday.
Tewksbury.
I'm preparing for a trial that starts March 9th. Could we do it more towards, March 23rd? And that gives us a couple weeks before the testing is supposed to start?
I don't have a problem, but
It's
just
not a couple of weeks.
so everybody knows, that testing's going forward on that day, no matter what.
I apologize, I just looked, I'm a family with Judge Hussein for a triple homicide in Fall River on that day.
Which day?
The one you just mentioned, which would be, I think, the Monday. Yeah, March 2nd. Thank you.
So Colin, you would suggest the 23rd?
No, that's right, no, not March 2nd, it's the 23rd of March. Right, I'm paneling and forward with that data, that is not the error. I mean, I could do, I mean, I'd certainly accommodate, you know, really, if you throw out there, March 10th, you could be here in the afternoon.
Yeah, Trav.
March 2nd. No, you,
She's been in custody for 3 years. Okay. The date of the murders of her 3 children occurred on January of 2023. And the defense has made a motion. They just want to videotape the state's examination. The state asked for an examination, a physical examination, a psychiatric examination of Lindsay Clancy, and all they want to do is videotape it. And the judge is like, no, we're not delaying this case anymore. The testing is going to happen. She's being examined by the state psychiatrist expert on April 10th. And he's like, this case is going to trial in July, come hell or high water. It's been pushed several times. January 24th, 2023 was the date of the murders.
That's fine.
for purpose, and I don't want to jam you up in regards to that, but it sounds like, quite frankly, the defendant may or may not really object to the testing. He just wants the opportunity to speak to his doctor. And so it may not even need a hearing in regards to that. But if it is, it's going to be a fairly short hearing. Most of this could be done through affidavits if parties have an objection to it.
I think what the court would probably want to know is what is it, when they say protection of their proprietary rights, what is it they're concerned about? Is it that they don't want to videotape the filling out of the forms, or is it the actual content of the test? And I just don't know.
And I don't want to put the comma in the middle of this either. I know that you're dealing with other parties who want their position made known to the court. So I think we could do that. Most of it can be done through affidavits. Then I can take a look at it, you know, and then if we need it, we can have a short hearing on the second.
Okay. Well, hello. It just froze up.
In regard, any issues regarding
I don't know if she's catatonic, but she's definitely suicidal. Kevin Reddington has said that before.
the discovery is required under Rule 14.4, I guess now, that is required prior to the evaluation. The Commonwealth satisfied that they have what they need.
Defense counsel has stated that he's turned over everything his experts have reviewed and all of the raw data from their testing. So relying on that, I don't believe there's anything else at this time.
All right, and if anything comes up just a little bit, I'm kind of going through my checklist to make sure that we have everything. So it sounds like the discovery for the evaluation is complete. There were 2 other motions that were filed. One is regarding juror information, and the other is the motion to bifurcate. Is that something we can argue for in a second?
Yes.
Well,
Yes.
all right, why don't we do that? Because I just got those 2, I haven't reviewed them, but that'll give me a chance to go through those motions as well. So if the parties talked about, again, under, I know the 3 of you know this very well, but in regards to the exchange of document reports, is there an agreement in regards to when Commonwealth's report is issued? Is there an agreement between parties that there'll be an exchange of the defense report as well as the Commonwealth report?
We haven't talked about it, but as soon as we have the reports, plan to turn them over and request theirs in return.
That's my practice, Your Honor, is that once the government's doctors file their report, I provide ours to them and vice versa.
And then, but, so when you get there, if that's any different than then we can address that in court, but that's been my experience as well. When they're both ready, there'll be exchange between the parties. Now, in regards to scheduling, well, we get the July date, trial date, then I thought, working backwards a little bit, is maybe a final trial conference date, rather than a week or two in, that my thought was maybe sometime in early June, because I imagine there'll be significant motions to eliminate, we'll have to address, and that'll give us time in case anything has to be kind of followed up on prior to the trial date. But I kind of just wanted to bounce that off of the three of you. What are your thoughts, Kamal?
I think that makes sense, Your Honor. I would ask that we keep the final pre-trials date set for July 13th in case any last minute issues come up, but I think it makes sense to have an earlier one as well.
Mr. Reagan?
I agree.
Yeah, so we'll keep the July 13th. That's kind of a true final trial conference we have. But we can pick a date sometime earlier in June, mainly to deal with motions to eliminate.
So council, looking at the week of first, or the week of the 8th, and the 4th, 5th, 11th, 12th.
I'm sorry, I scheduled to start a trial in federal court with Judge Saris. It's going to go 2 weeks on the 1st of June. So I'd say anything a week of the 15th. Yep, that's fine.
How's that?
That's fine.
All right. So that'll be the final trial conference. Parties can have their motions to eliminate filed a week before. And we can address any of those at the time.
Does that work with you with your trial schedule?
If it doesn't, I'll call you at the beginning of the schedule.
What?
Yeah, that works.
All right. And then
I'm sorry, Your Honor, you said a week before or 2 weeks before?
2 weeks, what we see 2 weeks,
2 weeks.
That's probably better for everybody's preparation, including the court. All right, the other thing is, on March 2nd, we're going to deal with those motions. Is it, the defendant's request that she be brought in or by Zoom just for those quick hearings?
I'd like to have you here. And I have to, if I may, on that issue, I would actually, strangely enough, like to commend the Sheriff's Department and our staff and Tewksbury that melded together incredibly and done just a marvelous job of transportation and supplies and taking care of our ancillary issues. So I just wanted to put that on record. Appreciate the help that the court provided in that regard as well. I would like to have her here if I could.
So we'll see that kind of gives it kind of a short runway, so we'll try and get that done.
Okay.
If not, if we can't get that done,
Not critical. I mean,
yeah, we may have to have her on by Zoom.
That's fine.
That's all.
Understood.
The other thing in regards to that, I know the court issued an order regarding the procedures, which is sealed because mainly dealt with security issues. I also just kind of wanted to let counsel know, if, and it's in the order, if either side or any of the parties feel that order has to be amended or changed, just bring it to the court's attention.
Of course.
Okay.
Thank you.
All right.
If I could just ask, the March 2nd date and the June 18th date, are those at 2 p.m.? Or?
If we can, yeah. Does that work for you?
It does. I just wasn't sure if we wanted more time for the motions than Monday.
Oh, June 18th?
Yes.
I think we should do in the morning on that. Right, I was thinking that's March, yeah, June 18th, because I don't know how long that, those are gonna be, so we'll do that. And let me see, 10 o'clock.
Thank you.
with regards, other than that, anything else that we need to address, first call?
No, Your Honor.
Defendant?
I don't think so.
All right, so we'll be in recess on this matter until we say March 2nd. And at that point, we'll deal with those motions that have been filed, any other issues that we have to. We've got the trial date, the 2 final trial conferences, and then if there's any issues regarding discovery, especially under Rule 14.4, prior to bringing it to my attention, we can deal with that.
Good.
All right?
Thank you.
All right, so with that, we'll be in recess on this case. Thank you.
Thank you.
Take it 3/2/26, PM, motion.
All right.
Transportation was a big issue in this case, getting Lindsay Clancy to court because of her paraplegia and the special needs that were required to have a certain number of caretakers with her to get an ambulette. It was a big deal. And we watched a whole entire hearing on that. And they made it happen. And she's in a wheelchair right now, and they're going to take her out. And this is a tragedy all around. I don't know if her husband was in the courtroom today, but he's been very vocal about supporting her. When we went over her medical malpractice lawsuit that she filed against her providers, we learned that she had auditory hallucinations and that she kept complaining to her providers, and they just kept doping her up with more and more medications. I'll explain a little bit more after we watch the end of this hearing. He lives in New York now. Thanks.
Quick save recess, please stay the courtroom.
I'm not sure what your username is because it's a bunch of letters and numbers. Oops, hold on a second.
Something more.
Bread CC8IF, how have you all made up your mind on this already? She killed her kids. Right, there's no question that she did it. That's not the question here. The question is, was she legally insane when she did it? Does she belong in prison or in a mental hospital? And that's what's going to be determined here. And there's a jury who's going to decide that. So I don't think anybody's made up their mind about anything. I'm not sure if you're just a rage baiter or what your deal is, but whatever. Every day, the trolls, every day with the trolls. I'm really, really getting tired of it. January of 2023, Lindsay Clancy, who was suffering from severe postpartum psychosis, took the lives of her children, Cora, age 5, Dawson, age 3, and 8-month-old Callan, with an exercise band at their Duxbury home, January 2023. We learned through her medical malpractice case that, oh my God, there's pictures of the babies here, which I can't even look at. She has claimed in her malpractice suit that a revolving door of doctors missed that she was suffering from bipolar disorder while loading her up with a myriad drugs from October to December of 2022, like Zoloft, Trazodone, Prozac, Ambien, Remeron, Klonopin, Seroquel, Ativan, Valium, and Lamictal. Clancy began to wonder if she was a psychopath. She claims that she was overtaken by a force with the voice of a man she began hearing since she started taking Seroquel the day that she killed her children. It wasn't until over a year after her arrest that she was diagnosed with bipolar disorder, a condition that antidepressants usually make worse, the suit said. Her husband, Patrick Clancy, filed a separate lawsuit against her doctors, claiming she was overmedicated at the time of the killings. At a hearing in December, which I think was the last one that we watched, Clancy appeared by video, and Kevin Reddington, who is one of the best defense attorneys in Massachusetts, everyone who knows him says that he's funny and he's kind and he's jovial. And yes, he did represent Jennifer McCabe at one point, but he's also said very nice things about me in open court during the Harry Turk trial. Remember when he was looking for a change of venue in the Turk trial? who I believed was hella guilty, by the way. I see people debating out there about the fact that I always think defendants are innocent. That's not true. You haven't watched my channel. You're a rage baiter and a moron. But Kevin Reddington appeared and talked about the logistical nightmare of getting Clancy to and from court and the special transportation that she was going to need and how it needed to be worked out because she has every right under the Constitution to be present for her trial. And I think he even said something to the court like, listen, she's suicidal and I don't want this on my head if something happens to her while she's here in the courthouse. Like, she needs the proper supervision and the proper medical providers to take care of her. And that was worked out because she did appear in court today. Right. He also warned, according to the New York Post, that she may try to kill herself during the course of the trial. She's been on suicide watch at Tewksbury Hospital since her arrest, which is a state mental hospital. And it's not a matter of whether or not she's confined, if and when she's likely found guilty for the taking of the lives of her 3 children, but whether or not she was in her right mind when she did that, and whether she should go to prison or whether she should go to a state mental hospital. I haven't made up my mind on that yet because I haven't heard all the evidence, but we have been over the civil suits, and it's heartbreaking. It's heartbreaking. But postpartum psychosis is real. It's a thing that happens. And, when people like Kelsey Fitzsimmons has her baby taken away from her because of allegations of certain things without having the right to be heard, which is a due process right under the Constitution, ask yourselves if that's why some women won't report postpartum. Because those kind of things can happen in Massachusetts and in other places. And Lindsay begged for help, and all these doctors did was pump her full of meds. Remember, she was at McLean Hospital, which is supposed to be one of the best places to go in this type of situation. And it's what happened to her was horrible. She's been on Zoom before. Why so important to get her to this hearing? But she has the right to be there. She has the right to be there under the law. Every defendant has constitutional rights, like it or not. They have the right to be present at their own trial. They have the right to confront their accuser. They have the right to be heard. They have a right to due process. They have a right to a jury of their peers. They have a right to be considered innocent until if and when the state meets its burden of proving guilt beyond a reasonable doubt. And a lot of people don't understand the burden, and a lot of people don't understand the rights that defendants have. She's not going anywhere, Candace. She's not going anywhere. Keep her locked up. She's not going anywhere. She's locked up. She's been there since January of 2023 in the state mental institution. She's not going anywhere, likely ever. Thank you for your thoughts. There are many women in the chat and many men whose wives suffered from postpartum psychosis, and it is real. Wendy says, look what happened when Kelsey admitted postpartum. Yep. Candace says, this has nothing to do with mental health. That's a blame. Did you read the lawsuit? Did you read about all the medications she was on? Did you read about the treatment that she received and the non-treatment that she received from the providers that she went to for help? Because if you haven't, then you shouldn't even be commenting. Noni says there's nothing they can do to her that's worse than what she's dealing with, the realization of what happened due to the meds. It's horrific. Right, Davy Cakes. Everyone involved in this case has already lost everything. No one wins. Is it possible to feel empathy for a mother with postpartum psychosis and also feel empathy for her children whose lives that were lost? Why does everything have to be so black and white? Why can't both things be true? Diane says the combination of that many drugs, the diagnosis, and the lack of intense monitoring is the real tragedy. Just keep writing scripts without follow-up. Here's Candace again, chiming in again. Research isn't going to be justified with killing your kids. Stop acting like it's okay. Did I say that I think it's okay that she killed her kids? Is that what I said? Is a person allowed to have empathy on all sides? I think that you have zero empathy is what I think. And considering that this is the first time you've ever been in this chat, it is likely that you're a troll who's just trying to rage bait me. Hold on. So that you can clip it. Block because I have a different opinion of you. Grow up. If you killed your kids and wanted to make an excuse for it, it wouldn't be justified. I think you need a little research. I think you need to learn the law. And when in Massachusetts, when a defendant claims mental illness and insanity, the burden shifts to the state to prove that she's not insane. That she's not insane. Okay? Nobody's agreeing that she should have killed her kids, Candace. I think you're misunderstanding. And if anybody in the chat wants to explain it to Candace can, now she's speaking of herself in the third person. George is getting upset. George is getting upset. Yeah, I don't know. It's rough. It's rough out here on the mean streets, isn't it? Not one person thinks it's okay. It's whether she lives in a prison versus a state hospital. Hilt says, my niece has suffered tremendously with postpartum psychosis. She tried to set fire to her home with her and the baby inside. Thankfully, she was able to receive the help she needed. She still doesn't have custody. It's tragic. It's horrific. Massdad says Candace doesn't have the ability to understand the legal nuances. I think that's it. I think she might need a different chat. I think you're right. Bless your heart. All right. Anything else on Lindsay Clancy before we go? Thoughts, questions, comments, concerns until we move on to the next topic. The next motion hearing will be March 2nd. It seems that nothing was really decided today, and the Commonwealth wants an opportunity to determine whether or not they want to agree to the taping of their expert examination of Lindsay Clancy. Massad, is it commonly done? It's commonly done here. I don't know why they're arguing that the testing, any written testing that they're going to do is proprietary and so it shouldn't be videotaped, but not that it would even be admissible. It's just for defense counsel to watch to make sure that proper questions were asked and that he knows what went on there. I mean, a lot of times it's always done, okay, the videotaping. In civil cases, we often, an attorney would go with the client for their IMEs and their medical exams that were defense exams. It's commonly done, so there's that. Bo, I did not hear that Clerk Jim resigned. Is that true? Massdad, did you hear that? Clerk Jim from Judge Beverly Cannoni's courtroom resigned? Voice of your heart says, I'm blown away with the lack of empathy here today. The amount of medication she was on is insane. She will live with this forever. We need to change the way we deal with mental health. Well, it was one person. It was one person who had a lack of empathy. But I do have the most empathetic chat, I think, on YouTube. And people who understand legal nuance and people who believe that two things can be true. And I listen, I agree with you. And you get one of them on a jury, forget about it. Amy says, no one is justifying her killing her kids. The reason is psychosis and lack of medical care. She's already living her life sentence in her mind and her body, right? Jim retired? Well, somebody said he resigned. Oh, he retired. Okay, there we go. All right, let's pivot over to Karen Reed and the hearing that happened yesterday, shall we? Here we go. For your convenience and your perusal, this is yesterday's Norfolk County Daily List Report. Every single day, if you go to the court website for the courthouse that you want to find the calendar in, you will find that day's calendar. And it will give you every single case that is on the calendar, what courtroom it's being held in, who the attorney is, and what time the case is being heard. So if you see here, the first section, the first page of yesterday's calendar from Thursday, February 19th, we have Judge Doolin. See, these are Judge Doolin's cases. We've got a hearing on competency at 11 yesterday for somebody named Robert Wilson Pratt. Then there was a motion hearing at 2 p.m. for Jared Schwartz. Then at 2 p.m., there was a lobby conference for Mr. Matthews. Then there was a lobby conference for Mr. Irizarry, an arraignment for Mr. Brooks, an arraignment for Mr. Busby, and bail review for Mr. Sharif at 2 p.m. Nowhere is there a hearing for Karen Reed or Aiden Carney or any. Oh, Judge Doolin was blindsided with this hearing yesterday too, says Scott McGinnis. It was in front of Judge Doolin. Yes, it was, because I have the tape. We're going to watch it. Page 2 of yesterday's calendar is Judge Donatel. Why do I find Judge Donatel interesting? Because the interview of Brian Higgins that took place at Brian Higgins' lawyer's house shortly after January 29th of 2022 and the murder of Boston police officer John O'Keefe took place at Judge Donatel's home. Because Judge Donatel is a female and her husband was Brian Higgins' lawyer. Okay. So that's interesting. And it'll be interesting to see if any of these cases having to do with Karen Reed are assigned to Judge Donatel. Okay. And then there's a page of Judge Connolly's calendar. And then there's a judge, looks like Judge Boudreau. And then a Judge Grant. There is no Krupp calendar. Nothing to see here, Tiff. Nothing to see here. So it wasn't even on the calendar yesterday. No, it just wasn't. Here's what happened. This was last week, February 13th. We're just going to catch up a little tiny bit. We're going to go back in time a little bit. Ted Daniel has been the only one who's been really actively and accurately still reporting on the Karen Reed debacle. And so let's look at his piece this is from the 13th. We played this the other day, but the whole stream was on something else. So hold on, we'll play this for you now. Remember, Robert Cosgrove, who is the special prosecutor assigned to the Aiden Carney cases, because Michael Morrissey has a conflict and he cannot prosecute Aiden Carney. So they had to hire a special prosecutor, and they hired a friend of Michael Morrissey named Ken Mello. And then Ken Mello went among the missing, and Robert Cosgrove stepped in. Robert Cosgrove has been prosecuting Aiden Carney, and he since has somehow been appointed to now try and prosecute Karen Reed because they really want to lock her up for something. And so Robert Cosgrove, all of a sudden out of the blue, made a motion to search Karen Reed's cell phones after Judge Cannoni ordered the return of her property. Judge Cannoni ordered her property to be returned, her Lexus and her phones. And there were two additional phones that were seized from Karen Reed in January of 2024 that the Commonwealth has never searched. And so Cosgrove made a motion under some bizarre search warrant number that doesn't exist in the system. Somehow it was linked to the Aiden Carney case. And Robert Cosgrove now says that he wants to have the ability to search those phones. They were never searched. They were seized in January 2024. They were never searched. They've had them for over 2 years. Karen Reed has been acquitted, but they really want to try and indict her on some new charges involving alleged witness intimidation or conspiracy to commit witness intimidation between Karen Reed and Aiden Carney. They tried it once. They tried it in March of 2024. They convened a grand jury in March of 2024 before Karen Reed's first trial. Her lawyers knew nothing about it. And even though it is said that a good prosecutor can get a grand jury to indict a ham sandwich, the ham sandwich of Aidan Carney and Karen Reed was not indicted. Apparently, they didn't have any of her cell phone data, or they would have used it at that original grand jury all the way back in 2024, but they didn't. What had happened was they didn't. I think, and you can correct me if I'm wrong, because I may be conflating my cases, as I do sometimes. I think that Brian Tully was the only witness at that grand jury. There were so many grand juries around that time. But whatever it was that Tully testified about in that grand jury had nothing to do with Karen Reed's cell phone data, because they just didn't ever search them. Yes, he shows up with his Velcro sneakers and he means business. That's right, Charma Lily. Okay. So this goes back to February 13th. This is Ted Daniels reporting. And Karen wants her phones back.
A special prosecutor working for the North
Cosgrove says we still want to search them. Made a motion in front of Judge Krupp. Judge Krupp denied the motion. We watched the hearing together. And I thought Krupp was going to grant the motion to search the phones. I was surprised by this. But again, we can't get the papers because they are impounded, which is what the word that they use for sealed in Massachusetts. This is from February 13th, the day the Krupp order came out. And this is
a special prosecutor working for the Norfolk District Attorney will not be allowed to analyze Karen Reed's phones, at least not yet. I'm investigative reporter Ted Daniels. Special prosecutor Robert Cosgrove applied to search the phones, but Judge Peter Krupp has denied that warrant.
And what was Judge Krupp's rationale for denying the motion?
I can't get into that because the order's actually impounded. But
okay, why? Why is the order impounded? Why is the order impounded? This is Benjamin Urbellis, who is her second lawyer on this part of the property return case. Okay. I forget who her first lawyer was, but I guess she fired him and hired this guy. Why is that order impounded? Makes no sense to me. I can't imagine what could be in there that they don't want the public to see. But if it's impounded, he's not allowed to talk about it.
I can say that I think the fact that it took 19 months for them to even apply for a warrant was a very significant factor.
That's Reed's attorney, Ben Herbalis. Following the decision, he tells me he immediately asked for Reed's phones to be returned to her, but that hasn't happened. State police seized the iPhones in early 2024 as a part of a witness intimidation investigation. It involves Reed's communication with Aidan Carney, the free Karen Reed content creator who goes by Turtle Boy. As we've reported, a previous attempt to indict Reed and Carney together for witness intimidation failed. In an email, Special Prosecutor Cosgrove tells me the return of the phones would typically require a judicial order. Cosgrove says the judge has not issued such an order.
But I'm sorry, didn't Judge Cannoni issue an order that all of her property was to be returned? That's the way I remember it.
And he has 30 days to file an appeal or motion for reconsideration.
Ben, I think people would be surprised to know that this is still going on.
We're all surprised that this is still going on.
Cosgrove declined to speak with us on camera. In his email, he argues it's important for the government to retain the phones to prevent any possible tampering or erasure of the contents.
Wait. It's important for the Commonwealth to retain the phones so that they're not tampered with. But Michael Proctor can lose his phone after it's extracted by the Commonwealth, and 13 years of data is found, and then he lost his phone. Katie says the phones weren't taken for that case, and I'm going to say there is no other case. There's no other case. They tried to indict them, and it didn't work. So I would argue that Judge Cannoni, her order goes for all of her property. And when did Robert Cosgrove become the special prosecutor against Karen Reed? We found some billing records for Cosgrove, and an engagement agreement, and I guess the part where it's about the case that he's hired for is redacted, maybe for attorney-client privilege, or maybe wasn't on there at all. But it's going to be interesting. We're going to watch the hearing. Cosgrove was there and did argue. Here we go.
A hearing has been set for next week, where Reed's team is expected to ask Judge Krupp to order the return of the phones. We'll let you know what happens. I'm investigative reporter Ted Daniel for your local station, Boston 25 News.
Right? So he just said a hearing's been scheduled.
Holy McElroy, look at those clubs. Yeah, baby, just got them this week.
A hearing's been scheduled for next week. Doesn't say what day. And it says Judge Krupp. Judge Krupp wasn't on the calendar yesterday, and we just looked at the Holy Daily Daily Calendar. Where's Tiny Jesus? We looked at the Holy Daily Calendar, and the Karen Reed case was not on there, and it wasn't under Aiden Carney, and it wasn't under any other case, and it wasn't under any search warrant. It was nowhere. Because Cosgrove is a loser, and losers focus on winners. Thank you, some golf girl. I think that was my favorite daily affirmation that we pulled. Winners focus on winning, losers focus on winners. Well done. Here's Karen from yesterday in the courtroom. Okay? We're going to listen to the hearing, so if you haven't heard this, buckle up, buttercups. This is from yesterday.
Contacted the Commonwealth and suggested, okay, could you get her property back? The Commonwealth provided her vehicle back, as that was...
It kind of starts like in the middle of his argument, but this is exactly what I was saying. A motion was made for Karen Reed to get her property back. Her Lexus, her phones, and whatever else they had of hers. I think that was it. Hold on. So it kind of starts in the middle of his sentence that was WBZ's camera person.
At the time, contacted the Commonwealth and suggested, okay, could you get her property back? The Commonwealth provided her vehicle back, as that was the alleged murder weapon, and she was acquitted, so they gave her that back. But they said, you know what, actually, we're not going to turn over her cell phones at this time. Her attorney at that time filed a motion for a return of property, and that sparked the Commonwealth to then file a motion to actually search the phones. This was 19 months after the initial seizure.
So that would have been, and so the initial seizure was January 24th, so this would have been September of 25 that it was seized, or thereabouts. But that it was.
This is Judge Doolin. Somebody said he was surprised that he was hearing this today too, and I just want to rewind a little teeny weeny bit because I saw my favorite court clerk, Margaret, sitting in.
So that would have been, and so the initial seizure was January.
There's Margaret. Hi, Margaret. We love you. We love Margaret. She's the nicest, kindest. She knows how to pick the alternates with the bingo balls and show the bingo balls to everyone. And she shows the bingo balls before she put them in the bingo roller. And then she pulled them out and showed them to everybody. Because she did it. I think it was in the Harry Turk trial that we watched, right? All right, here we go.
24, so this would have been September of 25 that it was seized, or thereabouts. But that it was searched, I should say.
It wasn't searched.
Oh, it was not?
No.
They sought a warrant for it.
They filed a motion on August 28th seeking to search.
Gotcha.
And there were hearings this fall. There were back and forth memorandums that I filed, that the Commonwealth filed, oppositions fighting this. Now, it's important to note that in the meanwhile, on August 29th, the day following the Commonwealth's motion for to search the phones, Diaz was decided. And Diaz was decided by the appeals court. And that was a case that was very important for both sides in their argument, and that Judge Krupp certainly asked pointed questions about at the oral argument. So that was sort of the seminal case that was dealt with in the argument and in the motions. Also over the fall, the SJC agreed to take up further appellate review of Diaz.
Yeah,
and
that's what Mr. Cosgrove mentioned in his final.
Right, and that's why I'm referencing it.
Okay, yeah, no, good.
So
there seems to be a new case decided in Massachusetts called Diaz, which is going to stand for the proposition that you got to return the phones, because it's like you have someone's whole entire life in your possession if you have possessions of someone's phone. Look who's here. Drop Microdots is here. Says they got 2 old phones and a pipe dream. Scott McGinnis says Doolin was seeming like, WTF am I hearing this for? He doesn't know anything about it. This is the judge that said, Mr. Bellerow, Mr. Betterow. That's right. The Julian says Margaret thought Karen was guilty. How do you know? How do you know that? I mean, if you're going to put something like that in the chat, can you back it up with any like actual facts? There we go.
That happened in the fall. So it was known in the fall that the SJC was going to be hearing Diaz. Meanwhile, arguments ended in our matter. All the memorandum was filed end of November. We waited 2 months for Judge Croft's very thoughtful and very thorough decision. In the meanwhile, the SJC heard arguments in early January on Diaz. The Commonwealth never moved for a stay of the proceedings, and they never did anything for almost 2 years.
Well, don't be surprised. Cosgrove doesn't file papers. Deadlines are not for Cosgrove. He doesn't believe in deadlines. He doesn't believe that he should have to file his papers by the due date. Like, he just does whatever the hell he wants, and there's no ramifications for his behavior. So his behavior is just going to continue. How much money has Cosgrove made so far? Here's Cosgrove right here in the front row. See how the prosecutor's bench is attached to the judge's bench as if they are one. As if they are one. This is the big courtroom in Norfolk Superior where Karen's pretrial hearings all took place.
Those funds. January 30th, Judge Croft rejects their motion. He denies their motion, and it was judicially rejected that they were going to be able to search Ms. Reed's phones. There's no pending case. That was it. I then emailed Attorney Cosgrove requesting that Ms. Reed's cell phones be returned and asking how she could pick them up. He said, nope, we're still not giving them back. So I filed a motion the following business day to put this on from this court. Mr. Cosgrove filed an opposition, I believe, the same business day, later on that day. That was 2 weeks ago. All of a sudden, yesterday, we get this motion to stay the decision of Judge Croft that Mr. Cosgrove only filed because he didn't like the decision of Judge Croft. He could have filed a motion to stay the proceedings at any time if he thought that Diaz was controlling or was going to change or potentially change the court's ruling.
When was Diaz argued before the SJC?
January.
In January, okay.
So with that, Your Honor, the Commonwealth is asking for a stay, I know, but I think it's important to recognize that this case is done. There's been a decision, and this is very common as far as something we might see in other cases where cases are dismissed or null props, right? The Commonwealth's argument here is that they have time to appeal. They're asking for indefinite time based on whenever Diaz might get decided, but I know Your Honor was a practitioner for many years, and I would suggest think about the times when we'd be in front of the court. Our client's case would get dismissed or null prossed. We ask for the property back. Never once does a judge say, well, the case was dismissed. However, Rule 36 hasn't expired yet. We're going to wait until all of that happens, and then we'll think about whether we do, or even worse, if it's a null pross by the Commonwealth, Rule 36 doesn't apply. And you know what? We're going to wait till the entire statute of limitations runs before we're going to give you this property back. That's not how things.
That's a great argument. It's a great argument. A null pros is when the prosecutor just decides to drop the case, right? They did that with one of Aidan Carney's cases. They just dropped it. They agreed not to prosecute it. And that's a great argument. Okay, so if they null pros a case, then they just think that they can hang on to whatever property they've seized until the statute of limitations comes up in case they come up with some more charges in the meantime, or are able to fabricate another case against this person, against this defendant. He's like, no, that's not how it works. Listen.
Rule 36 doesn't apply. And you know what? We're going to wait till the entire statute of limitations runs before we're going to give you this property back. That's not how things work. And that's what the Commonwealth is asking to do here today. There's a million different variables that could or would happen. That the law might change, the case might change. Even if the case changes, is that going to change Judge Croft's decision? Is that going to have any influence? I just want to point out the difference that In the appeals court decision of Diaz, that was a 123-day delay. Our delay is 5 times that. And the government interest in that was that the cell phones that were not allowed to be searched were allegedly used to create and produce child pornography. In this case, the government's interest is text messages. Allegedly.
Let me hear from Mr. Clancy.
Interesting. So Cosgrove moved for a stay yesterday because this Diaz case has not yet been decided by the SJC. We all know how long those decisions can take because we waited for the for the double jeopardy decision in Karen Reed's case for a very long time. Could take what, 90 days or more. And Cosgrove is saying, well, you shouldn't rule on this motion about giving her cell phones back until the SJC decides Diaz. That not really the way it works, because it's already been ordered by Judge Krupp to return the phones. And that was ordered on January 30th. Again, we don't have the decision. It's been sealed. I was going to watch, you know what? I'm going to watch it. Thank you. Thanks, Ms. Nancy, Ennis Nancy. Diaz is on the SJC YouTube channel. I want to listen to it. I love listening to appellate arguments. All right, let's hear what Cosgrove has to say about this. Here he comes. Oh, he's got look at him. He's got a beard now. Cosy got a little fuzz, I think. I mean, that looks like a little bit of facial hair to me. He's never had that before, has he?
So, Your Honor, let me just back up a little in the narrative presented to you by Mr. Urbelis. I'm not going to go through all of it, but let me pick it up from Judge Krupp's decision. There were 2 motions, just to clarify, before Judge Krupp. One was a motion that the defendant filed for return of the cell phone, and the other one was a motion from the Commonwealth to set up a taint team. Ultimately, Judge Krupp wound up denying the motion to set up the taint team. He made no order with respect to the motion to return the cell phone. I got Judge Krupp's decision the same day he issued it. We have a very efficient clerk's office in this court, as you know.
Yes.
So at about 4 o'clock, Judge Krupp's decision appeared in my inbox, and about an hour later, I would estimate, I had Mr. Urbelis's request that Ms. Reed would like her cell phones back as soon as possible, and could he get them on Monday?
That's because he's efficient and he probably checks his email, and maybe you don't. And I mean, good on you for complimenting how efficient the clerk's office is. You're not so efficient with filing your papers. And you also used to be a judge in that courthouse, didn't he? Used to be a judge in Norfolk Superior, and he came out of retirement for this. They call him Triple Dip Cosgrove for a reason. 2 pensions and a new salary. That's how he coined that phrase, I believe. Triple Dip Cosgrove.
I replied either that day or the following day, and my reply is, I believe, reproduced exactly in Mr. Urbelis's original motion. I said that we just got Judge Krupp's decision. I'd like to take some time to look at it and to meet with the Norfolk County District Attorney's Office. I intend to do that within a week or so and discuss with them our various options.
Understand that a week in Kazi time is like 9 months in regular time. He moves in slow motion. Like, really, a week? No. Dude, you've had her phones for over 2 years. You've been ordered to give them back. Just give them back. What are they afraid of? What are they afraid of? That's rhetorical. Friend of Dog gifted 10 memberships. Thank you so much. Welcome to all the new members. You are an amazing and generous contributor to the channel. And look at Bridget. Bridget gifted 5 memberships. Thanks, you guys. I love you so much. I love you so much. Happy Friday. Happy Friday, Amanda. Happy Friday. Freaky Friday, for sure.
Are we going to give the cell phone back? Are we going to move for reconsideration? Are we going to file a notice of appeal? And when I've done that, I'll get back to you as soon as possible. Apparently, Mr. Abellis having asked me to jump, the only acceptable response was how high, because in response.
Oh my God, dude, you wrong. You lost. You can't sit around and wait for the SJC to make new law. It's not how it works. What are they afraid of? What did they do to those phones? When did he become the prosecutor for Karen Reed? I have so many questions. Mr. Abellis is not going to let you get away with not responding to him. And you probably didn't respond to him at all. And so he's like, I'm coming to get the phones. I'll be there tomorrow. I'll be there Monday. Did you lose them? Do you still have them? Are they missing? Sassy. He's very sassy yesterday.
Apparently, Mr. Abellis having asked me to jump, the only acceptable response was how high, because in response to my response, as he just described, he filed a motion, captioned renewed motion for return of the cell phone.
Right, because you don't respond and everybody knows it. The world knows it. We watch it. You don't respond to deadlines. You don't file things on time. You ignore the deadlines by which you're supposed to file responses and motions. And it's like you're above the rules because you used to be a judge or something. I don't know. An outside observer might think that. So yeah, you're telling him, no, you're not going to return the phones. Yeah, he's going to make another motion. And Doolin has no idea what this is about. And he's like, how did I wind up here today?
For this court, and I filed an opposition. And basically what I said in my initial opposition was that under the rules of appellate procedure, we have 30 days to file a notice of appeal of the judge's decision. And it seems reasonable that we have the option to exercise that right before any decisions are made. In the meantime, as I had indicated to Mr. Abellis in my initial response that I would, I sat down with the district attorney's office and told them that went through all the options and what I saw as the pros and cons of each.
I don't know, Masted, are you here? My head just popped off and I think it's on its way to Connecticut. I'm sorry, you sat down with the district attorney's office and you went through the options and all the pros and cons. Isn't he conflicted? Why is he meeting with the district attorney's office on this if Marcy has a conflict now because they had to hire you? Is that improper? I'm sorry, what? You sat down with the district attorney's office? I thought they were conflicted out and that's why you're on the case. Hold on, I got to hear that again. And if they're not conflicted out and they can handle this, why are they paying you $400 an hour or something? However much his rate is now. And he just told us all in open court that he sat down with the DA. Listen.
Hey, in the meantime, as I had indicated to Mr. Abellis in my initial response that I would, I sat down with the district attorney's office and told them that went through all the options and what I saw as the pros and cons of each. And I told them that I thought the most prudent thing to do and that I intended to do was to file a motion to stay Judge Crook's order until such time basically as the...
He self-snitched. He didn't say I met with Ken Mello, who used to be the special prosecutor. We don't even know if Ken Mello is among the living or he's at the endless heaven buffet, as Kathy would say, from Gossip Rumor and Innuendo. He's not supposed to be sitting down with the DA's office if they have a conflict with this case. What in the actual F is going on here?
To stay Judge Crook's order until such time, basically, as the Supreme Judicial Court issued a ruling in Diaz. I did that, Your Honor, after reading the briefs in Diaz before the SJC, including the amicus briefs.
How much time did you bill the Commonwealth? How much time did you bill the DA's office for reading all the briefs in Diaz, including the amicus briefs? How many hours did he bill? Somebody needs to FOIA his billing records for February. Wow.
That were solicited. And I did that after listening to the oral argument of Diaz online.
And he bills for that too.
So
remember how many hours he spent allegedly reviewing every single one of Turtle Boy's YouTube presentations? And then at one point he capped his billing because he said, I promised I would only bill this many hours a month, but I really spent triple that. Triple dip, triple hours. Wow. I mean, you just can't make this up.
Argument of Diaz online. So this is not a case where the Commonwealth is saying, well, let's postpone things indefinitely because somewhere along the line there may come down a case in the future that will change things. This is a case where the key case relied on by Judge Krupp, and all
right, okay. See his face? Come to your screen if you can, and you're not on scaffolding or anything. Judge Doolin is all of us right now. Charmin Lily says he talks so slow he's almost talking backwards. He's all of us right now. I'm sorry, what? You want to wait to see what the SJC decides? How much are they paying this guy and why? Why? They hired a special prosecutor for Karen Reed's second trial because allegedly nobody else in the Norfolk County DA's office would touch it. Nobody else wanted to try that case. They were like, hell no, this is bogus. And so they hired Hank Brennan. They didn't hire Hank Brennan because they had a conflict. They hired Hank Brennan because nobody else wanted to touch it. So why is Cosgrove handling the, I don't know, grab bag prosecution of Karen Reed, trying to find something new to charge her with because they really, 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 really want to put her in jail for something? That's wild. It's wild. And he thinks so too. Look.
the key case.
He's like, oh my God, really? You're giving me a migraine, Cosgrove?
Case relied on by Judge Krupp, and I agree that he wrote a very careful and scholarly opinion. Maybe headed for some serious change, and also having listened to the oral arguments, I can tell the court that there are other cases that Judge Krupp mentioned that came in for questioning as to their significance by the court. I counted offhand about 4 different issues that were raised by the Commonwealth in front of Judge Krupp that were raised in the appeal of Diaz. So my situation, Your Honor, is I don't want to file a frivolous appeal. I don't want to file a motion for reconsideration that's frivolous.
Everything you do is frivolous. Everything you do is frivolous. Frivolous is your middle name. Should be Bobby Frivolous Cosgrove.
I want to make an informed decision, and it seems to me that the best way to do that is to see what the SJC says in Diaz. I don't know how it's going to come out. It may strengthen Ms. Reed's position. It may be no particular change, or it may undermine it entirely. That's the point, it seems to me, at which it is appropriate to make a decision on whether or not the Commonwealth is going to pursue an appeal or a motion for reconsideration. And to that end, I went ahead the other day and I filed a motion for a stay pending appeal, which Judge Krupp now has, I understand, under advisement and is not under advisement, under consideration. And my understanding is that he's given Ms. Reed 14 days to respond to my motion.
Okay, then why is Judge Doolin hearing this today? Will, I think maybe it's Cosmo. Maybe it's Cosmo. Not Cornelius, probably Cosmo. Like nobody knew Kramer's name until one day he slipped and it was Cosmo.
So that is out there pending. Mr. Abellis was a little faster on the uptake than I am.
You
I've
think?
noticed that in his memorandum of law.
You think he's a little quicker on the uptake than you are? Hold on, that deserves a replay. Oh my God, quote of the day.
Is out there pending. Mr. Abellis was a little faster on the uptake than I am. I noticed that in his memorandum of law in support of Karen Reed's renewed motion for an order to return property, he says, absent a court-ordered stay pending appeal, continued retention is unlawful. I'm not sure that's true, but I've now applied for a court-ordered stay pending appeal, which is under consideration.
You should have done that before. Now Karen Reed is being forced to pay more attorney's fees for her attorney to file a renewed motion to keep on your ass because you just don't follow directions correctly. He's way quicker on the uptake than you are because you don't even know about the uptake.
Applied for a court-ordered stay pending appeal, which is under consideration.
Look at Rebellis's face.
Stay pending appeal.
Look at his face. He's like, really? You did what now? I'm sorry, you did what now? I hope Karen is just adding up all of these attorney's fees that she continues to incur for the incompetence of people like Cosgrove and adding them all to her final bill when the state of the Commonwealth of Massachusetts won't be able to write a check big enough for her. They should just call it Reed-a-Chusets when this is all over. She can own you mofos and you keep going. Doesn't this help her civil case about the violation of her civil rights? I mean, just keep on with your bad self because there's going to be a lot more causes of actions that are going to be added to her current civil rights complaint. And this is just another way for you to keep on violating her civil rights by failing to adhere to court orders to return her flipping property. My God, man. Are we all in on the same joke? Listen.
Mr. Abellis was a little faster on the uptake than I am. I noticed that in his memorandum of law in support of Karen Reed's renewed motion for an order to return property, he says, absent a court-ordered stay pending appeal, continued retention is unlawful. I'm not sure that's true, but I've now applied for a court-ordered stay pending appeal, which is under consideration.
It's like, I'm not sure if that's true. Arbellis is like, are you kidding me? So you're saying in front of this court that I don't know the law? Okay.
True, but I've now applied for a court-ordered stay.
I just love this freeze frame so much. He's all of us right now. Ben Arbellis is all of us right now.
Pending appeal, which is under consideration by the court. I don't know if his position is that, well, you may have applied for it, but it hasn't actually been ordered yet. But let me turn to the dueling issues
Banjos?
of construction here.
How about the dueling banjos? Because we are like in deliverance country. We're entering deliverance country. Dueling banjos are appropriate here. That's gonna have to go on the playlist. Yeah, who's this kid over here sitting at Cosgrove's table? Is this his law clerk? White button-down tie, long hair. I don't know. Maybe it was Bring Your Son to Work Day. I really don't know.
Issues of construction here. Mr. Arbellis is relying on a statute relative to the return of property, which states that it's Mass General Laws, Chapter 276, Section 3, as I'm sure you've read. As soon as may be thereafter, that's thereafter, where there's still a possibility to produce it as evidence in a trial, all property seized under the...
What trial? There's no trial. There's no indictment. There's no charges. You got nothing. Squeeta. You lost. Just deal with it. Just deal with it. Mastad says that's a paralegal at the DA's office. Gotcha. Okay, thank you. I didn't mean for anybody to disparage the kid's looks. I just was wondering, we don't do that here, who it could be. Bottom line is they tamper with the phone, says I Love Dogs 1970.
Clause first of Section 1 shall be restored to the owners thereof.
Right.
I take it that it is the defense position that that is self-executing. I don't think that is the case. I think that a court order is required. Judge Krupp not having acted on the original motion for the court order, we now have the renewed motion before your honor. I have relied, as you know, on the Mass Rules of Appellate Procedure, which provide a length of time for the Commonwealth to file an appeal. The response, as I understand it from Ms. Reed, is yes, we recognize the Commonwealth can file an appeal. They can follow any lawful procedure, but that doesn't give them the right to hang on to the property in the meantime. I would cite two well-recognized principles of law, Your Honor. One is the rules and statutes, where possible, are to be construed harmoniously. And the second is
nothing. There is not, this is the furthest thing from harmonious, okay? This is like the most contentious proceeding in the entire Commonwealth of Massachusetts. Leave the girl alone. Okay? She's free. She was acquitted. She didn't murder John O'Keefe. Get over it. You're not going to find anything in those phones. Okay? At this point, it's a matter of principle. You gave the SUV back. What a waste of time and breath.
that we presume that the legislature, and I presume as well the SJC, in enacting the rule, does not make a barren enactment. Now, if the cell phones are returned to Ms. Reed during the period of appeal, if the argument is, go ahead, Commonwealth, take an appeal if you want, but give us the cell phones back in the meantime, the chain of custody is destroyed, and there is no guarantee as to the security of the information on those cell phones, or that the cell phones themselves cannot.
Okay. Praise be, cameraman, for now, or camera woman, zooming in on the judge. You want to talk about chain of custody? Are you joking? Did you watch Karen Reed's 2 persecutions? And now you want to talk about chain of custody? There's no such thing as chain of custody in Massachusetts. Pshaw. And now you're worried that she's going to tamper with something? Oh, you mean like Higgins cracking his SIM card in half and dumping it into 2 different dumpsters, Byron Albert destroying his phone or losing his phone, Michael Proctor just losing his phone right after it was returned to him by the Commonwealth recently?
A reset, it's the work of about a minute or less.
He's like, oh, look, Kazi knows how to reset a phone. Did they accuse her of resetting her phones before or right at the time when it was it Tully and Proctor who came to take her phones again in January 2024? And she had, I think she was on the phone with Jackson or Yannetti, and she's like, what do I do? Aren't they alleging that she wiped her phones then? So what do you expect to find on them anyway? Listen to this again, because the whole argument about chain of custody, for anybody who's listened to, who watched both trials or even one trial or even 10 minutes of anything about the Karen Reed case, knows that the Massachusetts does not believe in chain of custody. It's not important. They don't believe in metadata. They don't believe in chain of custody. They don't have to prove any of it. But if the judge says they do need it, then they just make it up and backdate the papers We know how this goes. Okay. Wow.
That we presume that the legislature, and I presume as well the SJC, in enacting the rule, does not make a barren enactment. Now, if the cell phones are returned to Ms. Reed during the period of appeal, if the argument is, go ahead, Commonwealth, take an appeal if you want, but give us the cell phones back in the meantime, the chain of custody is destroyed, and there is no guarantee as to the security of the information on those cell phones, or that the cell phones themselves cannot be reset. It's the work of about a minute or less, Your Honor. So there would certainly be no point in the Commonwealth taking an appeal or...
Aaron, just listen to the, like, watch what the judge is doing. And just think in your head. Somebody do this. I don't know who needs a job or wants to make a funny clip, but that would be perfect. Judge Doolin's reactions and his facial expressions and his hand motions to dueling banjos. Okay, you're welcome. You're welcome. Watch.
Cell phones, or that the cell phones themselves cannot be reset. It's the work of about a minute or less, Your Honor. So there would certainly be no point in the Commonwealth taking an appeal or contemplating an appeal if the end result would be that we would be left with nothing.
Okay.
So that is the Commonwealth's position.
You are left with nothing. You have nothing. You are grasping at straw. You are not just grasping at straws. You are grasping at wet paper straws. You know, one of my pet peeves is paper straws. Wet paper straws that dissolve within 3 minutes of your matcha frappuccino. Okay. This is a joke. You'd be left with nothing. No, you have nothing. You're trying to drum up something. You probably likely maybe already jailbroke into those phones and lied about it. And you just don't want anybody to know. You don't want to get caught tampering with evidence, if you will, because you already got such big problems with all of the MSP troopers assigned to the Norfolk County DA's office. Okay? You know it. I know it. We all know it. Sergeant No Good. We don't even know what he's done to be suspended. You got 4 Massachusetts State Police employees who have been indicted but not yet arraigned for the manslaughter of Enrique Delgado Garcia. What is it that you say you're doing here? Don't you guys have bigger fish to fry and bigger problems internally? I heard Michael Marcy is in the Epstein files. Is that even true? I don't want to spread a rumor, but people said that that's been known for a long time. I need receipts on that.
If the end result would be that we would be left with nothing.
Okay.
You are
so
left with
that is the Commonwealth's position. Sure.
I take it you want to respond, which I'll give you every opportunity to. I was told that there's an attorney here for the O'Keefe family that wants to be heard. He wants to call in.
Even Doolin thinks that's a joke. I'm sorry, what? A representative for the O'Keefe family wants to call in? I'm sorry, they're not a party to this litigation about Karen Reed's phones. Oh, is that why you guys really want Karen Reed's phones? So that you can turn their contents over to the O'Keefe family so that you can try and save faith in your bogus persecutions of Karen Reed? Are you guys, is that why you guys are doing this? Yeah. So Diller calls in. Oh, wait for it. Even Judge Doolin's like, what? He's not a party to this. Why does he even have the opportunity to be heard? Right. And Peggy and Paul O'Keefe are both in the courtroom. How did they know this was happening? Is Cosgrove also communicating with them? I just showed you the calendar. It's nowhere. You would have to have had inside information to have even been there yesterday. Somebody tipped off Boston 25 or WBZ because they were there. The O'Keefes were there. When did they find out that this was happening? Nobody knew it was happening. Listen. He's like, I'm sorry, what?
We would be left with nothing.
Okay.
So that is the Commonwealth's position. It should.
I take it you want to respond, which I'll give you every opportunity to. I was told that there's an attorney here for the O'Keefe family that wants to be heard. He wants to call in. I don't know why. I was just handed that. Let me hear from you, sir. Go right ahead.
Right. Kate Peter was there too. She accosted Karen in the hallway and was yelling murder or something at her. I heard that too. She knew.
So, Your Honor, Mr. Cosgrove did address one significant point. We agree. They have the right to appeal. The only statute or authority that Mr. Cosgrove has cited is his right to appeal. That's his right to appeal the court's decision, and that can go on without their continued use or possession of the cell phones. At this point, there is no lawful authority for them to continue holding the cell phones. Mr. Cosgrove says that Ms. Reed and her team believe that the statutes are self-executing. Yes, statutes are self-executing. The judge needs to follow the statutes. That's not for the court to use discretion whether to follow the law or not. We've cited in our briefs constitutional authority under Article 14. We've cited case law, and we've cited the statute. With respect to the continued possession of the cell phones, they were only authorized to be seized pursuant to a warrant in contemplation of a search warrant that has since been denied. There's no longer that basis. I think it's important to recognize, as the court stated in Commonwealth versus White, that, quote, individuals have a significant property interest in their cellular phones.
Yeah, that's the case I remember. It's Onyx White, right? Commonwealth versus Onyx White?
Yes.
Yeah, there was a lengthy period of time that the Commonwealth had the phone and they didn't search it.
They didn't search it, and the court said you're not going to search it.
Yeah.
And in that case, right, and that was only 68 days, and they said that was too long of a delay. And I know that was not a warrant search, but that was not a warrant seizure, it was a probable cause seizure.
Yeah, probably was.
But I think it's important that they also say many who own a cell phone, in effect, keep on their person a digital record of nearly every aspect of their lives.
Yeah, I get that.
We all know that.
Yeah.
So she's been without her phones now for 2 years. They've been going after her for 2 years. They've already failed. They just failed again. So we're asking that at this time. I also want to point out that I guess I was criticized for filing a motion too quickly.
I didn't take it though.
I didn't take 19 months.
Well, it wasn't the judge who said that. It was Cosgrove who said who criticized him for filing it too quickly, because he doesn't do anything quickly. But it did sound like that to me too, because I pointed it out.
Quickly.
I didn't take it though.
I didn't take 19 months. I didn't take 19 months.
File what you got to file.
But in any event, Your Honor, the Commonwealth cites their right to appeal. They cite nothing to say that they have the right to continue possession. We're asking that the court.
I think that's really the issue, yeah?
Yeah.
All right.
Thank you.
Okay, thank you. What's happening? Hold on.
Attorney Diller.
Okay.
By phone.
So,
Your Honor, may we approach?
yeah.
Come on.
I mean, yeah, come on over. Thank you, Decline. I love you too. Thanks for your 20. I mean, he's like, what in the what? Okay, that's Aaron Rosenberg, I think, who is one of the attorneys on Karen's civil case, who just ran up there. Cosgrove looks confused, per usual. Karen's angry, per usual. Who can blame her? Rebellis seems like a jovial, kind man. And Aaron Rosenberg just ran up there because he wants to hear what's going on too. He's like, okay, why? I'm here in the courtroom. I'm not being heard on this issue. I'm Karen's civil attorney in her, O'Keefe versus Karen Reed and Karen Reed versus everybody cases. I didn't ask to be heard. What right does this guy have to be heard? Diller. I think Diller's ruining the day he ever accepted this case because he's losing money. Charles Argo says, it became the Howie Carr phone-in show. Thanks for being with me for 11 months, John.
Diller, are you there? Hi, good afternoon, sir. How are you? Yeah, out of respect to you and your clients, I'll let you be heard. I know that there's a certain civil case aspect to that. I've told the attorneys here at Cybar that I will hear what you have to say and I'll take it to bene. And then I will let Mr. Herbalist or other counsel who is here respond to it, okay? You go right ahead, sir.
My interest here is we have a subpoena license and our members of the attorney's office. We need to question all of their extraction from here and reading cell phones. We also have a more specific page of including for the day. I understand that the court is prepared to turn back over there for potential and other ones to turn back over the cell phones. It would be relatively able to the issue or to have our expert be able to ask the cell phone extraction is the way.
Okay.
Okay. Did he really just say we would ask that we have an expert examine those phones? This is not a civil proceeding. This is not even a criminal proceeding. This is a fishing expedition to try and put some more charges on Karen Reed. Here it is, right here. I can't really boost his volume, so the captions are pretty accurate. I will repeat what he is saying.
My interest here is we have a subpoena license and our members of the attorney's office.
We have a subpoena. My interest here is that we have a subpoena pending with the Norfolk District Attorney's Office.
We need to question all of their extraction from here and reading cell phones. We also have a more specific page of including for the day. I understand that the court is prepared to turn back over there for potential and other ones to turn back over the cell phones. It would be relatively able to put the issue or to have our expert be able to ask the cell phone extraction is the way.
Okay. This is
Okay. We understand that the court might order the return of those cell phones. And I think he said, but before that, we want an opportunity to have an expert examine those cell phones. I can't wait to hear how he responds to this. This is a circus. It's a kangaroo court. And I like Doolin a lot. It's not his fault. He's like, what am I doing here? How did I get assigned to this? What in the what is going on here?
is what I would say. I will read whatever you send to me. And I will read whatever the defense on the civil case, Ms. Reed's counsel on the civil case wants to send. I'll give you, I'm going to have to do it. It's going to have to be quick. I'll give you until Monday to submit whatever you want to submit, and you can submit it as well, okay?
Yes, Your Honor. I just point out there is a subpoena. There's also an agreement that issue has been resolved with plaintiff's counsel. So I honestly don't know why this is being raised before Your Honor, but we're happy to submit in writing a response.
Yeah, why don't you do that? I think that would make it, I'll hear what both of you have to say.
Okay. Can we just ask that the plaintiff send it to us by email when it's filed?
Yeah, that's fine. If you could send it, Mr. Diller, send it to counsel by email. Might want to send Mr. Cosgrove copy too.
Thank you, Your Honor. I take no position on this, but
I
I appreciate seeing the package.
Yeah. Anything else? Nice to see you all. Take care. I'll take it under advisement. I have it.
Thank you, Your Honor.
All right. Have a nice day. Bye.
Okay, look and see who's in the courtroom. Oh, they didn't show
Corey
it.
Richens'
Okay.
trial is
Hello, brother counsel. Hello, brother counsel. We're not coming to you right now. Sorry. Sorry, dude. What is going on? Are we all on the same joke here? This was a secret hearing held in front of a totally different judge who knew nothing about the case. The O'Keefes were there. Kate Peter was there. Karen Reed was there. Her attorney was there. Cosgrove was there. The paralegal was there from the DA's office, which if they're conflicted off the case, why is their paralegal there? Judge Doolin taking this under advisement, giving them the opportunity to put in some more papers by Monday, and he'll read them. We won't find them. We won't know how to find them because there's no real index number in this case. It's being hidden somewhere behind the curtain or inside of a box as if we're on like, let's make a deal. What is going on? This is October of 2024. And this is Mark Diller in an October of 2024 hearing. Okay. Take a listen to this.
She's spoken to a blogger, Aiden Carney, who also goes by the name of Turtle Boy, 189 times over 40 hours that she has filtered information for him to post online. Countless other bloggers, if you just Google it, all profess that, and influencers online claim that they've been out to lunch, they've been out to dinner with Miss Reed, and she's talking freely about everything. And they're going and posting it online. Recently, which is
Those interviews, she's talking about the specifics of the case.
in what they're saying is she's freely talking about the specifics of the case.
Right. Right. She's out to dinner with people telling them that she's really guilty. Like, what is he even arguing here? Maybe the time for this, the time for you to make the motion about these phones would have been back when you were arguing whatever this was. I don't even know who this judge is in October 2024, because they've had her phone since January 2024 and everyone knows it. So you should have certainly known it because I'm sure the O'Keefes knew it. Maybe you should have acted a little sooner.
Conversations. It should be noted, Your Honor, I pulled this offline. She is raffling off for 2 winners are allowed to go to a dinner with her. For $50 donation, she's willing to go to 2 of her biggest fans to dinner with them. This is totally unprecedented. And if you want to understand the gravity of what she's doing, take a look at what happened in July of 2023, when Reed's own criminal defense team filed a motion to recuse Judge Cannoni in the criminal case based on untrue and unsubstantiated rumors that they pulled offline from Turtle Boy's own blog. They insinuate
There was a Venmo transaction between Julie Nagel and Ryan Nagel that said for Frank and Beverly on it. Like, that was real, right? That was a real Venmo transaction.
that she had some biases because, like I said, what's fiction is truth, what's truth.
And wait, wasn't the thing that Matt McCabe said to Aiden about Auntie Bev, whose beach house do you think I'm gonna bury your corpse under? That was real too, wasn't it? Or was that fake? I don't know what's real and what's fake anymore. I don't know. I don't know that I ever thought that I would say this, but apparently GrantSmithEllis is out there doing the Lord's work. Apparently, I think he's shifted his position, and I think that he has seen the light. Matt's brother. I'm sorry, it was Matt's brother. It was Sean McCabe who said that. Okay, sorry. Yeah, that's what I meant. I meant Matt's brother. I just can't keep all the BS straight. But here's a photo that Grant posted. Oops. From court yesterday, it seems. And Kate Peter is in the back of the courtroom. So here's this. There's Kate Peter on the left side of your screen. That's Karen. Apparently she was screaming at her in the hallway. I don't know exactly what she said. If anybody knows exactly what she said, let me know. But then Grant was outside the courthouse and he got this video from yesterday outside the courthouse. So I'm giving him credit for this video. And Kate Peter said, Karen said to Kate, who are you? All right. So this again is coming from GrantSmithEllis outside the courthouse yesterday. And Grant's mad as hell and he's not going to take it anymore.
So what's the verdict? You're gonna stop and say a couple things?
Sure.
Okay.
Let's check.
All right, so,
Obviously, no results
what
today.
happened today? What are you trying to do?
Well, I think we put forth everything that we could. We made our argument in court. I believe Ms. Reed's been entitled to her cell phones. So the prosecution filed a last-minute motion to stay Judge Krupp's decision to deny the search warrant. They filed that yesterday. It's been 2 years. So we're hoping that Judge Doolin carefully considers our arguments and our filings and orders the phones be returned immediately.
Why do you think the DA's office still wants the phone?
Right?
They want to get her for something. They've already failed once in front of a grand jury. They presented evidence trying to say that she...
That was Rebellis. That's what I've been saying. They want to get her for something. They want to get her for something. Look at Janet Reed looking beautiful, as always.
In front of a grand jury, they presented evidence trying to say that she conspired to intimidate witnesses. They failed. They couldn't even, this wasn't even a ham sandwich. They couldn't even indict her. So now they're trying to do what they can to get her on something else. So we'll see what happens. I expect that Judge Doolin should rule in our favor, and hopefully Miss Reed can move on with her life now.
When we couldn't hear Attorney Diller, what did...
Why didn't Judge Krupp order the phone? I could be back again.
The O'Keefe family was only heard de bene. Did that interest you?
That was Grant. There's Christina Rex chasing after with a microphone. Let's see if she gets anything.
Karen, any feelings, the fact that they want to hold on to your cell phone, indict you on something?
I'll say that Attorney Diller had nothing to do with this hearing, so whatever he wants to say, he can say, but this is between the Commonwealth and Miss Reed.
But why didn't Judge Krupp order the return of the phone?
Karen is staying silent. Maybe she's shooketh about what happened between herself and Kate Peter inside the courtroom.
That's still pending, right?
Yeah, we'll see what Judge Doolin says.
Turn.
How did the media know this was happening yesterday? There's
We're
a lot of
experts
media
at this.
there.
What are you talking about?
All right, thank you. All right, guys, take care.
And so that's that. Please hit like to push the video out. Thank you. But wait, that's not all. Because there's more. Hold on, there's more information on this. I just have to figure out where I put it. Microdots posted 2 phones. The disgraced Norfolk County DA just cannot let go of what they believe is their last Hail Mary chance to charge Karen Reed. Oops. Well, They've lost their reputations. No one trusts or respects them anymore. People snicker and point at them in public. All they have left is 2 old phones and a pipe dream. Well done. Oh, here are some comments that GrantSmithEllis got from Robert Cosgrove yesterday after court. Makazi G coming in hot. Let's see what he says to Grant.
I'm not pregnant anymore. I can run.
That was Christina Rex. She said, I'm not pregnant anymore. I can run. Oh my gosh.
Yeah, I don't guarantee I'll answer this.
He said, yeah, I have no guarantee I'll answer your questions.
What's the goal with the cell phone?
See what's on them.
For what purpose?
See if it's evidentiary.
Just look at him. He shrugs. She's like, what's the purpose of looking at the cell phones? He's like, I don't know. Just see what's on them. See if it's evidentiary. Evidentiary for who? For what? Are you working for the O'Keefes now? Are we all in on the same joke? That's what you call, that is the definition of a fishing expedition. That is the definition of a fishing expedition. Just to see what's on them. Listen.
What's the goal with the cell phone?
See what's on them.
For what purpose?
See if it's evidentiary.
Of witness intimidation?
You're self-snitching. You just admitted in front of everyone that it's a fishing expedition.
Is that still the charges for trying that?
Well, it's still an active investigation.
It's still an active investigation. The witness intimidation against Karen Reed or conspiracy to commit witness intimidation is still an ongoing investigation. Who's investigating it? You?
See if it's evidentiary.
Of witness intimidation? Is that still the charges for trying that?
Well, it's still an active investigation.
Active
It's not a no.
investigation.
It's not enough.
I think there's a lot of questions about why the Norfolk DA's office in particular still wants to get do you have an answer to that?
Did you hear what she said? She said, I think there's a lot of people who think that the Norfolk DA's office still just wants to get Karen Reed. What do you say to that?
The Norfolk District Attorney's Office wants to get Karen Reed or anybody else. I think it's just following the evidence to see where it leads.
How do you think things will turn out after today? I know we didn't get an answer.
I have no idea.
Wait, what?
Yes, I think it's just following the evidence to see where it leads.
How do you think things will turn out after today? I know we didn't get an answer.
How do you think it'll turn out after today? He's like Chris Melton on the stand with the closed eyes. I have no idea. I don't care because I'm smiling all the way to the bank. I'm smiling all the way to the bank. Because I'm still billing. Even if I don't win, I still get paid.
Can I just ask you, so these phones have been around for a long, didn't you already get all you needed off these?
No.
That reporter said, so let me ask him, these phones have been around for a long time. Didn't you already get everything you wanted off these phones? He's like, no.
For a long, didn't you already get all you needed off these?
No.
Do you think that there's evidence on these phones that you weren't able to obtain via Aiden Carney?
I don't know.
I don't know.
Won't know till the phones are examined.
And have you made a decision about whether or not you're going to appeal the rejection for the search warrant?
No. If you heard the court argument, the Supreme Judicial Court has a case which could push us either way. Could prompt the judge to reconsider his decision, or might confirm him in the decision he made. So we're just trying to do the best we can on the basis of the best possible information.
And so the best case outcome for you right now would be to wait for that SJC case to be decided.
Right. That's what I asked the judge to let us do.
Yeah, we're just gonna wait until the law changes. Maybe it'll change. Maybe it won't. We're just gonna wait. We're just gonna keep hoping against hope that the law will change. And we will be able to do something with these phones and maybe potentially, possibly find something. Maybe not. We're not sure. We just want to see if there's, they could be of any evidentiary value for what charges. We don't know. We just want to get it for something. Some kind of witness intimidation. If it's true that Kate Peter accosted Karen Reed in the hallway and was screaming things at her, couldn't that also be considered witness intimidation? Are you going to prosecute her for witness intimidation, or are you only prosecute people who don't think that John O'Keefe got hit by a car? What is it that you say you do here?
Thanks very much.
And the possessory interest in the phone?
I'm sorry, what's your question about the possessory interest?
Isn't that overriding?
Well, from my...
He's genuinely stumped by Grant's question. It's like, well, do you think he looks like Sean Connery with his white beard and mustache?
Point of view, the possessory interest in the phone is handled by the initial search warrant, which gave us permission to seize the phone.
It's a slight distinguish without a difference as to Diaz, but I understand your point. Thank you.
Grant's like, I'm smarter than you. Yeah, slight difference. Hold on, because there's more. There's always more. I feel like there's always more. There's never not more, because there's always more. Hold, please. Okay. These are in Kate Peters' own words. What she said to Karen after court, as posted by Aiden Carney. You want to hear that? You guys want to hear that?
Under advisement, right? So he hasn't just.
Okay, hold on. I know you do. XOXO. You know you want to. In Kate Peters' own words, I guess this was that spaces or something that they do on the twat, as Broken Baker calls it. Here it is.
I walked up behind. I'll tell the story so that so I walked up behind her, they call the judge takes the motion under advisement, right? So he hasn't decided whether or not he's going to compel the Commonwealth to give back the phones. I would say that he is, right? And so he takes it under advisement. Everyone can leave. And Benny kind of looks at me. I was with Benny Blanco, and he's like, "You want to go?" And I'm like, "Hold on. I'm going to follow her," right? So I wait till she gets up, and we kind of get to the door at the same time, and I let her go ahead of me. And as soon as we're out in the hallway, I'm like, "Hey, Karen, why did you factory reset your phone? Got nothing to hide?" And she turns around with the bugged out, fucking rage-filled, angry eyes and goes, "Excuse me?" And I go, "Why did you factory reset your phone? Do you have nothing to hide?" And she goes, "Who are you?" And then kind of gets in my face. And I'm like, "Who are you?" And she goes, "What do you mean?" And I'm like, "I know exactly who you are." And she goes, "Of course you know me." And I said, "No, I know exactly who you are. Why did you give those addresses, the witness addresses, to Turtle Boy? What was the purpose of that?" And at that point, one of her supporters was behind me going, "Kate, come on, come on." So I walked down the stairs and I go, "You're a fucking murderer, Karen." And then the court officers are like, "All right, quiet down." They don't give a shit though, because they know it's true too. Everybody does. That's the thing, is Karen, everybody knows exactly who the fuck you are. And not in this quasi-celebrity, narcissistic, "Oh, everybody knows." No, we know who you are. You disgusting bitch.
Yeah, she's the female OJ.
Female OJ?
The worst kept secret in the world.
I mean, OJ didn't say.
Okay, now explain to me, if you will, how what Kate Peter just admitted that she said to Karen Reed, who's been acquitted, by the way, of murder, is different from what Aiden Carney said to Jen McCabe at whatever sporting event that they were at, the lacrosse game or whatever they were at. Remind me again, what did Aiden Carney say to Jennifer McCabe that he's been charged with felony witness intimidation? How is that different? How is that different? Admittedly, I don't remember exactly what Aiden said to Jennifer McKay, but it's on tape. He taped it. What did he say to her? Why is there selective prosecution of the laws in Massachusetts? Why are only certain people charged with felony witness harassment? Karen's certainly a witness. She's got a civil case pending against her. She's a defendant in a civil case. She's a plaintiff in another civil case against everyone. How is what Kate Peter just admitted to doing, and I'm sure there were many witnesses if it was in the courthouse, how is that any different than what Aiden did, except for Alienate Sharpness says he was much less unhinged. And then Lemonade says she's protected, meaning Kate Peter. How is that not witness intimidation? I'm just trying to figure out the rules in Massachusetts. Like certain people can, certain people can't. Depends on whether or not you believe John O'Keefe was hit by a car. She has said that she's not working for the district attorney's office or the MSP. She's not working for Tully or Mello or anybody. How is that any different? But she's said, virtual juror says because she's a state actor, she gets immunity, but she has said she's not a state actor and she's not a paid agent. You can't use it as a shield on a sword, right? She did this inside the courthouse, right as they walked outside the courtroom into the hallway. Didn't happen outside because nobody got it on camera. And so I'm just curious. I'm just, putting it out there, just spitballing with you guys. Explain that to me. Anybody? I don't know. I guess I'm just confused. I mean, she's admitted to it right there. She said, she told us all. She told us everything that she did or said. So I don't really know. Again, rhetorical. Back to the chat. Jody says, Mel, whatever Cruz shares, could it affect future trials for E? Thanks for bringing this case to us. Many of us would never have known. Stay. But I don't know what you mean. Whatever he shares, he's obviously not going to be able to talk about certain things about the case, any privileged things. I mean, when he comes on, there are certain things he's not going to be able to answer. So I'm sure he knows exactly what those things are. So don't worry about it. Thanks, Jody. 3-5. Paranoha says, did you hear Court TV reporting Ashley Benefield was moved after an alleged assault on an officer? I did. I haven't had a chance to watch anything about it yet, but many of you did send it to me, so we'll cover that too. Billy Tibbet says, the Commonwealth have held onto Karen Reed and Aiden's phones because they accessed them illegally and they don't want the evidence of that available for the civil suits. Thanks, Bill Tibbs. If you have 5. Karen DePasquale gifted 5 memberships because she's amazing. Thanks, Karen. Jack says, watching from the hospital, recovering after breaking my hip. Oh, I'm so sorry. I'm so sorry. Only in my late 50s and fell on carpet. You'll keep me smiling. Oh, girl, I'm sending you all the healing vibes across the pond. That's rough, man. A broken hip is really painful, and you are, in bed for a long time. So I'm happy to keep you company. MF says, I would love it if jurors were made to explain why they voted the way they did in the verdict. No, that is you cannot inquire into jury deliberations or why anybody did anything. It is not a thing. It is not a thing. You cannot get into the purview of what happened in deliberations unless there's something like discrimination or tampering. I bet a lot more people would be less inclined to just go with guilty because they wanted to go home. Yeah. We'll see what happens. Thank you for your 10. Doctors, if we can't see it, we medicate it, said Charlie. Thanks, Charlie, for tuning in from down under again. Jersey Queen said, thanks, Mel, for presenting something light today for us to get our patooties in a bunch about after the week we've all had. Yeah, it wasn't, there's really nothing funny about this stuff, but it's lighter than Walking While Black and then A Real Life to Kill a Mockingbird in front of our very eyes. Thanks, Jersey Queen, for your 10. Sees the Day says, thinking of you and all the cupcakes when I go to a concert tonight. I need sanity in this insane world. Good. I hope you're going to something fun. Thank you for your 5 and have an amazing time. Music is good for the soul, as we say. Strong Leg says, I've seen bread mold faster than Cosgrove can get a point across. Thanks for 5. Denise says, I was once on so many meds for mental health issues that I would fall asleep while driving and even while teaching. That's very dangerous. Too many meds is a real thing. I got a new doctor. Praise be. Thanks, Denise, for your 10. That was going back to Lindsay Clancy. Super. Thanks for tuning in from Denmark. Says, I'm behind on the live now, but wow, I'm looking forward to hearing from Mr. Cruz. Thank you for the coverage of the case. Thank you for being interested in the case. Cruz Cupcakes is not changing my name yet. Cruz Cupcakes forever. Thanks for your super chat. Age of Nefarious. It's Tish. Cupcakes, be as brave as you can. Support sisters. Thank you. Don't go anywhere because I've got Trooper David DiCicco's original witness statements of Kayley, the niece of John O'Keefe, and you're going to want to hear what she said in her original witness statement and how her witness statements morphed over time. Bonnie says, waste of time, life, money, energy, kangaroo, court, circus, TGIF to you and the cupcakes. Thank you very much, Bonnie Mae. And Bridget says, Judge Doolin is going to going to CF McCarthy's to have a drink and play a game of pool after this shit show. Thanks, Bridget, for your 5. Ellen says, thanks, Melanie. I knew you'd do this perfectly. Thank you, Ellen, for tuning in from Denmark. This court is being held in the land of the lost, says Holly and Johnny. Jessica says, the song suggestion, Land of Confusion, Genesis. Well, that's been on our Karen Reed playlist since like day one. Both versions, actually, the Disturbed version and the Genesis version. Thanks, Jessica. Bridget says, Melanie Little, you rock. Thank you. Thanks for your 5, Bridget. And Scott McGinnis says, when Kate Peter entered the courtroom, well, okay. I mean, how is that not witness intimidation? Scott? Thank you, Susan, for gifting 5 memberships. You're so kind and generous. And look, and then Noni to 3 gifted 5 memberships also. Thank you. You're the best. You guys are the best. All right, you guys want to take a look at Kaylee's original witness statement that was taken by DiCicco? Of course you do. Here we go. Looky. There's been a FOIA dump, and I believe it's the work of Queen Corey Hopkins. Looky, dated February 3rd, 2022, on the letterhead of the Commonwealth of Massachusetts Department of State Police to Lieutenant Brian Tully from Trooper David DiCicco. The interview of, it's redacted, but we know it's Kayley, the niece, at 1 Meadows Avenue, Canton, Mass, relative to the investigation into the homicide of her uncle, John O'Keefe. That's how we know. On Sunday, January 30th, 2022, at approximately 1 p.m. Oh, look at that. The day after John O'Keefe's murder, I, Trooper David DiCicco, was present at 1 Meadows Avenue in the town of Canton. The residence is home to homicide victim John O'Keefe, as well as his niece and his nephew. I had an appointment to meet with Paul O'Keefe, John's brother, and ask some questions about the relationship between John and Karen Reed. Investigators were also looking for someone in John's family to possibly provide the passcode to his phone. Upon completion of my brief meeting and conversation with Paul, he brought his niece upstairs, and the 3 of us talked for 5 minutes. Upstairs, like you were on the 2nd floor? That's weird. Or upstairs from the basement. I don't know. He brought his niece upstairs, and the 3 of us talked for 5 minutes. I asked Kayley to tell me about Friday night. She said her Uncle John's friend, Mike, came over with his daughter, blank, who is Kaylee's friend. She said that John and Mike went out, and she and Mike, I think this was Mike Camerano, right? Mike Camerano's daughter stayed home until about 11 p.m. when Mike came to pick her up. She said she went to bed when Mike's daughter left. Okay. Blank, Kayley said Karen came into her room at about 4:30 a.m. and told her that John never came home. She ran into the other room to get blank's phone because blank is not permitted to have her cell phone in the bedroom overnight. All right. So I guess maybe John took their cell phones at night, the kids. And so she went to get it from John's room. Karen asked Kaley if John had contacted her. So she looked at her phone and observed a text from John at about midnight asking her if she was okay. I would like to see the metadata on that text message. Did the police get the metadata on that text message? Did they get a screenshot of that text message? Because I never heard anything about any text message. And I know I've been over every single piece of paper in the Karen Reed persecutions. And I don't remember ever hearing anything about John texting Kaley to find out if she was okay. What time was that text message? Kaley said she missed the text because she was sleeping. Well, also because the phone wasn't in her room. Even if she was awake, the phone was in John's room. I don't know. I'm confused. Karen told her to call John, and she did, but he did not answer the phone. Kaley said Karen then began calling somebody's dad, her friend's dad, Mike Camerano, and his wife. Karen used Kaley's phone to call Jen McCabe. Karen then went out to look for John around 5 a.m. Kaley did not wake up and hear when Karen came home prior to 4:30 a.m. when Karen entered her bedroom. Okay. At what point does Kaley say in this statement, one day after John O'Keefe's murder, Karen said, "Oh my God, I wonder if I hit him. Oh my God, he got hit by a plow. Oh my God, John's dead." All of the things that in the O'Keefe versus Reed lawsuit, Kaley is alleging caused her severe, intentional, emotional distress. Does anybody have Cardi B? Hello? Wouldn't it be in there? Kaley said she doesn't know the passcode of John's cell phone, but she may be able to guess the login for the Ring camera system. Oop, there it is. She gave DiCicco the password for the Ring camera system. How many videos were deleted? Missing? I know one that was missing, the one when Karen got home. Because one of the troopers said in his report, I saw the video of Karen returning home to One Meadows at such and such time, and that video disappeared. She said John used the same password for most things, and it was likely blank or blank. Kaley said if he needed a symbol for the password, it would probably be blank. And that's a pretty long couple of words that are redacted there. I thank Kaley for talking with me, and the interview was terminated. XOXO, Trooper David DiCicco, Massachusetts State Police, Norfolk County SPDU. Okay, can anybody tell me where's DiCicco now? Does anybody know where DiCicco is now? Did he get transferred? Is he missing? What is he rehomed? So of course they got into the camera system. Of course they did. Right? Nothing about John's dead. No, I hit him. No, he probably got hit by a plow. But wait, there's more, because there's always more. "23 days later, 23 days later, Kaley is interviewed. What do they call that place? The kids place where they interview kids. Hold on. The witness advocate. Well, no, it was the witness advocate and Proctor interview Kaley at the DA's office 23 days later. and says this. On Friday, January 28th, 2022, Kayley was home with John, his friend Michael Camerano, and his daughter, Blank. Kayley stated Karen was at her home and planning on meeting John and Michael later on that night. Kayley stated that her friend and her hung out at the house until approximately 11 p.m. when the friend was picked up by her father, Michael Camerano. Kayley stated she was home by herself at that point and she went to bed. At approximately 4:30 a.m., Karen entered Kayley's bedroom screaming and acting frantic. Well, that's a new part. Karen ran into John's bedroom to retrieve Kayley's cell phone. Kayley stated it was a rule that when she went to bed, she had to keep her cell phone in John's bedroom. Kayley began calling John and texting him with no response. Karen then had Kayley call Jennifer McCabe, and put Karen on the phone to speak with her. After speaking with Jen, Karen left the house and told Kayley to call Michael Camerano and have him pick her up. Kayley stated that Karen changed her stories while speaking with Jen. When the two first spoke, Karen informed Jen that her and John got into an argument earlier in the night and she dropped him off. Prior to leaving, Kayley could hear Karen and Jennifer talking over the speakerphone. Kayley heard Jennifer inform Karen her and John got into an argument and she dropped him off. Karen responded saying that they did not get into an argument. When Karen, Jennifer, and Kerry returned on Saturday morning prior to finding John, Jennifer went inside and talked to Kayley. Jennifer told Kayley that her, Kerry, and Karen were going to look for John. Kayley only spoke with Jennifer prior to them leaving that morning. Kayley stated that when Michael picked her up, they could not shut the garage door. Michael had to manually shut it. Kayley stated Karen would park in the garage and had a control for the door. Michael Camerano dropped Kayley off at her house Saturday morning. Kayley stated Karen texted her that morning asking if she could come over. Kayley stated Karen arrived with her father, brother, and sister, and they stayed for 30 minutes. XOXO, Trooper Michael Proctor. Now, while the story has morphed 23 days plus Jen McCabe, it still doesn't say that Karen said, John's dead, John's dead, he might have been hit by a plow, John's dead. Maybe I hit him, I could have hit him. That's still not here yet. Are you picking up what I'm laying down? Some parts are new. Karen changed her stories while speaking with Jen. When they first spoke, Karen informed Jen that her and John got into an argument earlier in the night and she dropped him off. Prior to leaving, she could hear Karen and Jennifer talking over the speakerphone, and she heard Jennifer inform Karen her and John got into an argument and she dropped him off. Karen responded by saying they did not get into an argument. Kayley overheard Jen McCabe tell Karen, "Oh, you and John got into an argument last night. Don't you remember?" And she dropped him off. Jen McCabe told Kayley that Karen dropped him off at 34 Fairview. Well, that's interesting. Don't you think? I wonder if the Reed team had these statements because Kayley testified at both trials. The cameras were shut off. Nobody really knows what she said other than if they were there and reported on it. I think the first time David United said, "I'm really sorry that you have to be here today. I have no questions for you." Don't you think if they had these statements of Kayley that she would have been asked some questions? Because I think at the second trial, she did say that Karen said all of these things to her. John's dead. And I mean, we're here, right? So now I need to, oh, it's not on this. I don't have it on this computer. Hold on. Well, it's all right. I'm going to get it right from the Plymouth County Clerk's office. Hold, please, because you're going to see the allegations in the lawsuit of the O'Keefes versus Karen Reed, and you're going to see what they're alleging now. The story is. And I certainly hope that Karen Reed's team has these statements now, at least, maybe, perhaps. So let's get on over to Plymouth Superior and see exactly what the complaint says. Wow. I mean, if they are using this poor girl, and I told you this from the beginning, that I felt so bad that they would drag these children in to testify, because the long-lasting effects of having to testify in a case where, well, in the first trial, Karen Reed, it was a hung jury, and the guilt those children must feel thinking, oh, is everyone mad at me? Did I not do a good enough job? When Karen loved those children and by all accounts was very generous to them and bought them things and expensive gifts, and John didn't want them spoiled. And that's the things that, you know, they would fight about. And the guilt that must have been involved having to testify against a woman who by all accounts loved them. She would bring them to her house. She would bring them to her house and made a room for them and took them places and bought them things. And to have to live with, did I not do a good enough job testifying because Karen's not in jail? And then the second time, she's acquitted of everything except the drunk driving. And now the guilt that they must feel again, because maybe they think their family's mad at them because they didn't testify well enough to get her put behind bars. Well, we're here and we ain't got no quit and we're doing it. So hold on while I download this. Oops. Again to the new system, because we like papers. We like receipts. I mean, wow. Just wow. Just when you thought it couldn't get any worse for these kids, it did. They lost their parents. Hank Brennan, scum that he is, read into the record a text message of Proctor's that indicated that their father may have let's just say may have died on their mother's gravesite. Maybe the children didn't know anything about that. Maybe it's not even true. Why would Brennan read that into the record to tell everyone in the world that? That was disgusting. That was not the world's business, by the way, in my opinion. Let's take a look at the complaint and what the O'Keefes allege Karen said to the niece that caused her intentional infliction of emotional distress. Hold, please. Because I'm sure none of us remember the exact words, and these are allegations in the complaint. No wonder Mark Diller is so pissed off that all of these documents are coming out now. Mark Diller is a plaintiff lawyer. Plaintiff's lawyers get paid on contingency, which means they don't get paid unless they win. And if they win, they get a percentage of the recovery. If they don't win, they lose everything, including all of the expenses that they have paid on the case. This is the complaint that was filed August 26, 2024. Paul O'Keefe, Peggy O'Keefe, Mr. O'Keefe, the father, and Kaley against Karen Reed, the Waterfall, and McCarthy's. It is 22 pages. All right, we're just going to get to what they're alleging Karen said to Kaley. Okay, here we go. Paragraph 39. On January 29th, 2022, at approximately 4:30 a.m., defendant Reed knew that she hit JJ with her SUV. Nevertheless, she woke up JJ's 14-year-old niece, Kayley, and talked about JJ's death, talked about hitting JJ with her SUV, and otherwise involved Kayley in her frantic calls about JJ's death. Do you see this? Do you see this paragraph 39? You know what's so funny about that? Not really funny, like haha, but funny, ironic, and funny, disgusting is that Kayley never said any of that to DiCicco or Michael Proctor. Lies, lies, lies. Yeah, we have an emoji for that. But wait, there's more. Okay, that's against C.F. McCarthy's. That's against the waterfall. Do, 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 do. Here it is, Kayley versus Karen Reed. This is count 13 of the plaintiff's complaint, negligent, reckless, and or intentional infliction of emotional distress. Paragraph 147, Kayley learned of JJ's death or injury when defendant Reed woke Kayley up at approximately 4:30 a.m. on January 29th of 2022. Defendant Karen Reed knew Kayley was vulnerable, having already lost her parents at age 6. Nevertheless, in Kayley's presence, defendant Reed spoke on speakerphone to various people between 4:30 a.m. and 5 a.m. on January 29th of 2022. At all relevant times on January 29th of 2022, Kayley heard defendant Reed say, JJ never came home. Maybe I did something. Maybe a snowplow hit him. Maybe I had hit him. Maybe I hit him. We were in an argument. Maybe he got hit by a snowplow. Do you see how the story has morphed for money? Anyone? Wow. Maybe she was young. I'm not saying that anybody told her to lie. I'm not saying that. How did her story change between what she told DiCicco on January 30th, what she told Proctor 23 days later, and her testimony at the trial? As a result of the conversations between defendant Reed had in her presence, Kayley perceived the injuries caused to her guardian, Uncle JJ, and perceived the injury-producing event. At or about 5 a.m., after waking Kayley up and informing her that something had happened to JJ, defendant Reed left Kayley home alone. Defendant Reed intentionally and or recklessly inflicted severe emotional distress when she woke up Kayley and informed her that she hit her uncle or that a snowplow hit her uncle. Defendant Reed either intended to inflict emotional distress in Kayley or knew or could or should have known that emotional distress was likely to result from defendant Reed's conduct. Defendant Reed's conduct was extreme and outrageous beyond the bounds of decency and was utterly intolerable. Then, after JJ was declared dead, defendant Reed came to the family house and feigned concern. Rather, it became clear that defendant Reed was only there to collect her belongings and to take possession of the murder weapon. The emotional distress suffered by Kayley was severe and of a nature that no reasonable person could be expected to endure it. Defendant's extreme and outrageous conduct caused Kaley aggravated emotional distress manifesting in physical symptoms. Well, I do not doubt that this child has suffered severe and long-lasting, maybe even permanent emotional distress. I don't doubt that for 1 minute. I do doubt that Karen Reed caused it based on the two statements that we just read. And that's the final cause of action in the complaint that was filed August 23rd of 2024. That's the lawyer speaking, but those are the lawyer's allegations. Those are Diller's allegations. Why do you think they're all getting ramped up? Why do you think all the trolls are getting ramped up? This FOIA request may be very damaging. May be very damaging, not just for the civil suit against Karen Reed, the Waterfall, and McCarthy's, but, you know, there could be other people implicated. But that's all we have time for today. And so with that, I say, oh, Dr. Jen, you're going to see Dave Matthews in September. Did you get tickets today? They went on sale. I got shut out for everything because AXS, that website for tickets, stinks. Where are you going? Thank you. I mean, you're so lucky. Thanks for your 5. Lozzie says, I'm going to watch To Kill a Mockingbird on stage next week. I'm going to cry. Love you, cupcakes. What a week it's been. I know. It has. It's been very, very draining. Thank you, Betsy. Betsy says, have a wonderful weekend. I love you with all of my heart. Thank you, Betsy. I love you too. That was via Venmo. Oops. Thank you, Deidre. I will listen to that. Burn Bright Karen, Jen says to the call to the police, he got out of the car. Yeah, that's been around for a long time. We've had that for a long time, right? He got out of the car. How long? I don't know how long. You know, yeah, that's not necessarily new. It might be the first time you heard it. Thanks, Karen, for your super chat from Canada. And April, welcome. Thanks for becoming a member. Evolve My, thanks for your 10, says catching up. There's more. Oh, there's always more. It's never ending. Thanks, April, for becoming a member. Burn Bright Karen says, Carrie says, phone to police. John would have called his niece to let her know he was okay. Karen could only find out if John called her by waking his niece up. Jen says, when asked on the phone to police, John O'Keefe got out of the car. Yes. Yep. Thank you for tuning in from Canada. And Kat Randall gifted a membership. Kat's awesome. Totally awesome. All right. Thanks, moderators. Just a girl from the 6 said this way earlier. Getting here late. I hope you're listening to the podcast of Cameron J. I'm currently drafting him an email. I am so mad. I would not recommend anybody to contact anybody related to the Edgar Foss case. Leave that to the attorneys. Leave that to the law enforcement. I would not in any way condone that. And so, just guide your actions accordingly. That's not legal advice. That's just, it's just I just wouldn't do it. You don't want to wind up in a court file somewhere at some point. You know what I'm saying? Witness intimidation laws differ everywhere. And I get a million troll emails a week, and I'm sure he probably does too. Thanks, Maz. I couldn't do this without you. Thanks, everyone. I'm going to be talking to Ahmad Cruz tonight, and I will let you know when he's going to come on the channel, so that you hopefully have enough time to join us. Okay. So look forward to that. He's the attorney for Edric Foss, and there are many, many, many things that were not allowed to come into the trial. And I think he wants to talk about it and answer your questions. And so I will do it live instead of taping it, because I like it when you guys can engage and ask questions and, do all the things. So I think that's it for today. Unless you have any further thoughts, questions, comments, concerns, I will see you very, very soon. I can't tell you exactly when because it's not scheduled yet. Okay. All right, guys. I love you with all my heart. If I don't see you soon, I'm going to die, but I am probably going to see you soon. I have dinner plans, so I need to go eat Stay cool, stay kind, stay classy. I know you can do. I mean, I know you can do it. And above all, stay safe because it's a jungle out there, my friends. Peace. Do all the thing YouTube likes. Like the stream, share it, comment after the stream is over. That helps too. Love you guys. Bye.